About to, though.
Where's everybody else? The hell's going on here?
They're coming. Maybe.
I'm driving to Laradice tonight, boys.
Mr. Chairman, we are live streaming now.
Thank you, Mary Beth.
Oops.
Welcome to the Blockchain Select Committee. For those just joining from the opening ceremony of the Wyoming Hackathon 2020. Tyler's come over from that video stream into this video stream to join us. It was a great little opening. It was great to hear from the governor in support of the Blockchain Hackathon this year in the Stampede. Representative Lindholm, you were sort of closing up, and here comes Caitlin. Hi, Caitlin. Welcome. We're just getting started here. We're waiting on a couple of members to join, and one of the first things that we do want to do to making sure that we've got some continuity here for those that didn't participate in the opening ceremony is to give a little bit of a opening and introduction about the hackathon and what events are there, how we get there, folks that want to participate, want to watch, where they need to go to do that. So Representative Lindholm, you want to provide a few opening comments? I realize it'll be redundant for those that were just over in the opening ceremony, but tell us a little bit about this 2020 Wyoming Hackathon, and Caitlin, feel free to jump in.
Yeah, so it's a pretty exciting aspect. This hackathon evolved from all of a sudden Wyoming being like the worst in the nation in regards to crypto and blockchain to being #1 by far. And so there was a lot of interest coming to the state. There's companies coming to the state. And so this is Caitlin's brainchild. She said, why don't we work with the university on hosting our own hackathon? And that was 3 years ago. This is our 3rd annual Wyoming Hackathon. I think last year we gave away a little over $200,000 in prizes. I mean, it's bonkers. It's one of the best funded, best prize money hackathon in the nation as it currently stands. So it's a really exciting aspect, and it gives us the opportunity to demonstrate that Wyoming's still plugging away, still being #1 in the nation in this regard, but also to demonstrate that those companies coming into the state of Wyoming are here and are sponsoring local Wyoming kids and events. And last year this will be the 3rd year that the Shoshone kids have participated. The Shoshone kids, for those of you that don't know about the Shoshone kids, they're #1, they're all-stars, and their teachers are by far and away some of the best in the state. They've taught these kids how to code. They've made them competitive, and now it's almost like a sport for these kids. They just come down to the hackathon and clean up. I think that last year, Caitlin, they walked away with like 25 grand. Oh, you're muted.
Yes, and even the year before, there were only 3 that came the year before, but they also won a cryptocurrency, a couple $1,000 each of the 3, and then they agreed to be mentored by engineers from Switzerland and Slovakia. So from Switzerland to Slovakia to Shoshone.
It's pretty wild, man. It's really cool to see these. I mean, last year at the Wyoming Hackathon, and a lot of people got to see this, and it was just a special moment where these Shoshone kids, I mean, these are like 13-year-old kids, 14-year-old, and they're wearing cowboy boots with legitimate cow stuff on the bottom of those boots. I mean, these are legit cow kids, right? And so they're standing there debating Cardano's infrastructure with Charles Hoskinson. And that's Wyoming, right? That's the Wyoming we live in now. And because of this committee, because of the people in this room, that's become a reality. So it messes with me every time. It gets me a little teared up. It's pretty cool. I'm excited about it. That Wyoming's future is getting brighter every day, and this room of people right here is a lot of the reason for that. So it's pretty cool, Mr. Chairman.
Well, thank you, Representative Lindholm and Caitlin. This is obviously the 3rd year that we've done it. We hope to bring everybody back in person next year. This is a special event this year, but it certainly is incredible to see everyone gathered in one place. We had it at our new engineering building, ERB, last year, walking through there, hearing people talking code, working on the whiteboards. We intentionally designed that building so that we had collaboration spaces. It was a pretty perfect venue. You're walking around, you're hearing people speaking different languages to one another as they're coding. Don't really always know what's going on, but it was a pretty special event, and we look forward to getting everybody back there, all the members of this committee in person for the next one. But we've got, I think, a great event this year with everybody engaged virtually. We've got this streaming live. We've got today's committee meeting as part of the event. So I appreciate all of the work that both of you have done in organizing this and the hard work that's gone into it, and look forward to participating further over the rest of the weekend. Any other thoughts before we get going on the agenda today? Caitlin, Representative Lindholm, anyone else about the WYO Hackathon and Stampede?
Sure, Mr. Chairman.
Yes, go ahead.
Just to share some information with the legislators, so you realize that what you have invested your time and stuck your necks out doing has really started paying off. I know you know that, but just some statistics about what's going on at the university. We've now crossed more than $1 million in total funds raised for the university between the 3 hackathons and the contribution that IOHK made. There's another one coming to the university, so we will be well above $1 million. And like Representative Lindholm said, chunks of that have been paid out in the software competition, which is what a hackathon is. And we're batting well above our weight class because the university has put itself behind this event and absorbed some of the facilities cost in years past. But this year, of course, we're not in person, which is a shame, but it's changed the event, and we invested in a professional virtual reality conference producer. So you can actually, when you go to the website and look around the sponsor booths, it's all in virtual reality. It's very cool. It's not just a bunch of Zoom meetings like we're all used to doing, including this one. But also, very importantly, just so you're aware, just in the past week since the Kraken announcement, more than 300 new registrants came in to the hackathon. We're at almost double the amount of participation versus last year. In each of the prior 2 years, we had about 400 developers, and of course, everything was on campus. So we did accomplish the goal of bringing people to Wyoming so they can kick the tires, which is what this whole thing has been about. This year, it's mostly virtual, pretty much all virtual, but very importantly, we added a law conference to try to bring the Wyoming bar up to speed on what all these laws are, as well as attorneys from outside the world. And I must say, I know the Wyoming Division of Banking has been deluged with public records requests relating to the Speedy Banks. The Kraken news took a lot of people by surprise. And the law conference, which is a new addition to the hackathon this year, we were able to get continuing legal education credit for it. And literally, it's got several hundred attorneys from all over the United States who are trying to get up to speed, and we welcome all of them. It's a little late. Some folks got ahead of this because they understood the magnitude of what Wyoming was doing, but it's not too late for those who are trying to get up to speed for your clients and bringing economic development into Wyoming via the Speedy Banks and other initiatives. Thank you, Mr. Chairman. Excellent.
Thank you, Caitlin. And if you are watching and you want to look into the hackathon itself, instead of just coming in through the YouTube or the legislative website, the website for the hackathon is wyohackathon.io, wyohackathon.io, and you can click attend in the upper right-hand corner. You can find out information about the events, which will be ongoing for some of the programming conference will be ongoing for around a month. So there will be a lot of activity, certainly in the next few days and then in the month ahead. Any final thoughts on the hackathon before we're part of the hackathon? So we'll be talking about it all day, certainly, and all day tomorrow. But anything else before we get started with the agenda? All right, seeing none, this is a great time to call the roll.
Didn't hear.
Senator Driscoll.
Here. Thank you for holding off, Mr. Chairman.
No worries.
Senator Nethercott.
Here.
Representative Greer.
Here.
Representative Limholm.
Here.
Representative Yin.
Excused. He'll be here shortly.
Mr. Kaufman.
Here.
Ms. Long.
Here.
Mr. Ravel.
Here.
Co-Chairman Rothfuss.
I'm here.
Co-Chairman Olson.
Here.
All right. One thing for folks that haven't tuned in before and aren't familiar with our blockchain select committee, we kicked off as the blockchain task force 2 years ago, so 2 full legislative sessions ago. And one of the strengths, I think, of this committee, which we've continued to bring forward, is that it's not just legislators. We have industry and technical experts that are appointed by the governor as liaisons to the community. They bring the technical knowledge. We have a good cast and crew of legislators that are part of this. And one of the priorities that we've had throughout is to be very publicly engaged and stakeholder engaged to ensure that we're hearing what industry, what stakeholders, what enthusiasts need as we're moving forward. So we're not just building regulation in the dark and trying to restrict the sector. We're trying to enable it and build that framework in Wyoming, as Representative Lindholm and Ms. Long have stated over the last few minutes in discussing the blockchain stampede. So we value that engagement. We invite public opinion. If you want to provide public testimony on any of our topics and have not yet signed up, please contact through the website and we'll try and get you in. We'd like to hear from you. We've got a robust agenda for the next couple of days. We'll be talking about a lot of the topics that are really being talked about in industry right now that we haven't already attempted to tackle, which includes decentralized autonomous organizations. We're going to be getting into that shortly with our working group updates, KYC AML portability, digital identity. And then we'll also be talking about some other legislation that we've been trying to move forward, get some updates. And then you'll see over the next couple of days a strong agenda of topics. If you want to look at that agenda or look at the materials, please go to wyoledge.gov and get through to the select committee on blockchain, financial technology, and digital innovation technology. That'll let you follow through at home. And with that, let's get started with the agenda. Mr. Co-Chairman, any thoughts before we get rolling?
Actually, yes. What I wanted to say was, I was going to mention this during the opening, but I wanted to wait for Representative Yin to show up, and now he's here.
Now. He's here.
So welcome, Representative Yin. And just wanted to give a shout out to this committee, and especially to the members of this committee who have really been here from the beginning. Governor appointees like Caitlin Long, Senator Driscoll, you've been with us since the beginning. Senator Nethercott, you're almost in the beginning. You joined us pretty early, but more specifically, Representative Lindholm. I wanted to give a shout out to Representative Lindholm. I think that if you look at everything that we've done in Wyoming and you just go back through our history and the start of all of this 3 years ago with a couple of bills and this idea that was very foreign to a lot of the world and very foreign, especially to Wyoming, and in comes Representative Lindholm with this new idea. And I still remember to this day sitting in a legislative chamber and a senior representative who I respect very much walked up to the podium with a big metal chain and put it on the podium and said, "This is what the blockchain is." And although of course it was a joke, but the point is that is really what, Wyoming had no concept of what the blockchain or virtual currencies or any of that was at that moment. And Representative Lindholm championed that idea, got so many of us interested and passionate about it. And I just think enough can't be said about the members of the legislature who put their necks on the line for an idea that was foreign to Wyoming and decided to move this forward. For the two governors that signed bills into law, for the citizens who have moved here, who have been here, who have been involved. I know we're going to talk about the hackathon throughout the next 2 days, but I couldn't get started with business without at least throwing that shout out to everyone. So thank you, Mr. Chairman.
Absolutely. Thank you, Mr. Co-Chairman. And, you know, it's already been a great month, and last month was excellent as well, as we welcomed the first Speedy Bank charter, completion of that charter by Kraken. And hopefully we'll have the second charter with Avanti completed very soon. Ms. Long, looking forward to that. So we're seeing the return on this hard work that the committee has done and the task force has done over the last few years. And that's, I think, very rewarding for all of us. So great work, everyone. All right, with that, any further comments before we get started with the agenda? Committee, seeing none. First item on our agenda is updates from the working groups. We've had 3 working groups active, trying to look at ways that we can tackle legislation related to decentralized autonomous organizations, KYC AML portability, and digital identity. We've got plenty of time this morning. We'll have an opportunity to take public comment on each of these topics, and I believe that we have interested parties for each of these topics to weigh in and help us work through it. We're working towards legislation, I think, in each of the 3 areas, and we'll get into more detail there. But we're going to start this morning on decentralized autonomous organizations. Mr. Co-Chairman, you are chairing that working group, and I know we've got some updates and some information. Mr. Kaufman has been involved, and we've got some presentations and public comment available for that. So, Mr. Chairman, I'll turn it over to you to sort of lead that update, and then we'll hear from Mr. Kaufman, Mr. Wright, and any other public comment that we have available. Floor is yours, Mr. Chairman.
Thank you, Mr. Chairman. So, gals, we're chugging along. You're going to hear here in a moment from Aaron Wright, Christopher Allen, and Mr. Kaufman, of course, that are going to give you the more substantive update on where we're at. The goal is to definitely produce hopefully be able to reduce something into writing that this committee can begin to digest and look at. Right now, we're still, I guess, at that intellectual level where we need to discuss it further. In our last meeting, Mr. Kaufman had another commitment, and unfortunately wasn't able to join us during the Dow discussion. And if I recall right, there was considerable discussion between the lawyers on the committee. I think where I don't know exactly where we want to start, but where I would like to start is with Mr. Kaufman, since that's where we essentially left off. I think I don't know if my order of presenters in front of me shows Mr. Kaufman you last, but I would invite you to have that opportunity to speak first on this, because and we could kind of summarize where we left off, I suppose, if need be in the discussion. But there was as I recall, a pretty decent discussion between Representative Greer and Senator Nethercott, and your opinion was missing. So now we value it. So we could start there with on your update, and then we'll move into to Mr. Wright and Mr. Allen.
Thank you, Mr. Co-Chair. Can everybody hear me okay?
Yep, go ahead, Mr. Kaufman.
Maybe just to give a little bit of context with respect to the discussion and where we've at least gone from there. I was sharing last time some of at least my thoughts and a few concerns about where in statute this DAO organization would live. And Admittedly, I had some initial reluctance to park it within our LLC Act, only because I'm really protective of our LLC Act. It's very good. But to be perfectly honest, after a lot more contemplation and debate, I actually think that we can put it within the LLC Act without really risking much of anything and make it sort of, a type of LLC, if you will. Much like we do within corporations, we have closed corporations, we have professional corporations, there's different flavors of corporations. I actually think that kind of after going back through the act a little bit more closely, that we could do that. I do think that the DAO is much more workable, at least in my opinion, as an LLC than a corporation, at least to start. And so that was the context with which Mr. Wright and I have had some discussion. And I'd like to let Mr. Wright take it from here, because I know he and at his university, they've been doing some work to try to issue, spot, and identify. But I wanted to at least start there, Mr. Co-Chairs, that I think, again, after some serious contemplation and maybe even with not a lot of work, we could create this entity as a subtype of LLC. I do think there's a couple of logistical challenges just with respect to figuring out what the DAO's obligations are going to be internally in terms of corporate governance and what it can opt in and opt out of with respect to the LLC Act. But at the end of the day, I think that's absolutely doable. I think it's probably the best way to do it, and so that's kind of where we've landed right now.
Thank you, Mr. Coppin. I'm not sure we have Mr. Wright here yet because we're slightly ahead of schedule, and he might be intending to show up at 9 o'clock. Have we seen him yet, Mary Beth?
Mr. Chairman, we have not. I do know that he did receive an invitation and he did respond. So
okay, yeah,
well,
we're a little bit ahead. Mr. Coppin, what do you think about going over to Mr. Allen? Are you ready for your comments, or were you waiting to build off of Mr. Wright on DAOs?
No, I'll be glad to begin. So actually, I wanted to commend the committee to look at an article that just came out in CoinDesk, which is one of the more authoritative news sites for blockchain. It came out on Monday. I hate the title of it. It's called "DAOs Will Never Govern the World at This Pace," but in fact is a very, very strong proponent for why I am interested in DAOs and why I think Wyoming should do so. So one of the points that they make at the beginning of this article on Monday is that, if you're trying to do a DAO to get investment, to try to get around token regulations, to try to raise and allocate money, it's the wrong vehicle for it. And I think a lot of the mistrust that Senator Nethercott and others have is that people might try to use this legislation to get around some of those types of rules. But that's not why many people want to use this form. And I'll quote her: "People are seeking new forms of organization in areas where hierarchical organizations are failing: public health, climate change, preservations of culture, inequality, etc. DAOs offer the potential to organize collective intelligence to address complex questions and manage shared resources." And I think that's an important point here, which is that, people are kind of frustrated with traditional governance of traditional ways that equity is shared among people who are making decisions together, et cetera, and they're looking for some alternatives. And I think we all agree that LLC laws come really close to it, but they really want to make it easier for themselves. And if the state of Wyoming can make it easier for them to be able to decide for themselves some in some governance ways that they feel is more participatory, more collaborative, more effective, we should make it easier for them to do so, but also help them avoid the minefields of temptations to try to do to get around token laws and things of that nature. So I really do encourage this work. I'll be glad to put Senator Nethercott and of course Chairman Olson, et cetera, to kind of walk them through the scenarios that they're interested in, and work with anyone else to try to figure out how to prevent the people who are might try to abuse this type of thing from doing so. That's it.
Thank you, Mr. Allen. Appreciate that. And I think those are good points that we need to take into consideration, that we don't just want to be some type of a safe harbor for shenanigans. We really want to be using DAOs for positive purposes, and I think there are ways that we can accomplish that. That's one of the things that I had a conversation with Mr. Wright, who has joined us, and we'll give him the floor next to try and challenge him to ensure that we were threading the needle so that we were getting the benefits of DAOs, and at the same time making sure that we provide sufficient protections, and that if we're going to grant liability through our limited liability corporate structure, that we would do so in a way that honored the kind of trade-off there. So with that, Mr. Wright, welcome, and appreciate having you here. We're just slightly ahead of schedule, but we have been just started the topic of our work on DAOs and trying to figure out how we can implement that framework within Wyoming statute. I know you've done some work on that, so the floor is yours, and welcome. Please introduce yourself to the committee for the sake of protocol, and then tell us what you've been up to.
Thanks so much, Senator Rothfuss, and very nice to see everybody again. By way of reminder, my name is Aaron Wright. I'm a professor at Cardozo Law School in New York. Have a background in law and technology, and my research focuses primarily, if not exclusively, on blockchain technology and law and policy related to it. Since we chatted during the last meeting, we've taken we've gone down the path of really exploring in more detail what a DAO-related piece of legislation could look like. So to that end, I've been working along with students at Cardozo Law School to go through the Wyoming LLC Act to look for specific provisions that may need to be amended or could be amended in order to streamline the creation of these new digital organizations. I've also had the pleasure of working with Matt Kaufman, who's also on the line, to think through some of these issues. What we're exploring is potentially creating a new subpart to the LLC Act that would enable the creation of a structure called a DAO. At its root, it still would be an LLC, but certain provisions could be either amended or somehow clarified in the subpart to make it easier to create these types of entities. So we're still in the process of going through each provision of the Wyoming LLC Act in order to identify areas that we believe could be improved. These provisions primarily root down to areas where record keeping is expressly noted, that it should be in some sort of paper form, or issues related to meeting requirements or other requirements like that. There's also kind of a recognition, at least for folks that do want to participate in these DAO-like structures, they're not looking for the same type of fiduciary relationship that I think we saw, at least with earlier LLCs, and increasingly we've seen certain opportunities, at least via an operating agreement, to limit or potentially narrow those fiduciary obligations. So it's really, in my mind, about setting appropriate defaults such that conceivably we could get to a point where somebody is able to file, let's say, a certificate of formation or the equivalent document in a way that that allows these parties to set up these organizations how they're intending to do that. We're also thinking about, and kind of to the previous point towards the end, ensuring that if the state of Wyoming was going to provide some form of limitation of liability, that the relationship of the parties, the identity of parties, and the ability of the state, and or other law enforcement related organizations would be able to identify all the members of the DAO and also would be able to notice them in some sort of way and identify them. So that's been a large part of our effort. Also, in order to make sure and understand fully what this potential and proposed amendment would look like, we're working to put together a couple case studies whereby we can explain why and if this proposed legislation was put into place, how this would be beneficial, and or helpful. So we're not yet fully done with that, but we've begun that process. It obviously takes some time to go through each provision of the LLC Act to make sure that we're kind of capturing everything and being comprehensive and thorough. But we've made good progress there. And I think in the next several weeks, if not the next month, we should be able to really have a clear path on what something here could look like. So I know it's a little open-ended, but I'm obviously happy to answer any questions and really do appreciate the opportunity to provide testimony today and also the opportunity to at least begin to explore what a DAO-related piece of legislation could look like.
Thank you, Mr. Wright. Committee questions. Yep, Representative Greer. Glad to see you have questions.
Thank you, Mr. Chairman. Mr. Wright, one, I appreciate the path because I think Mr. Kaufman and Senator Nethercott kind of discussed this concept of the sub-chapter. So I appreciate that. I also appreciate how you're moving forward with it to look at what needs to be amended to make it work properly. And then also I think case studies would be very useful all the way around. So all that's really good. I do have a specific question though, because we talk about the reduction of fiduciary obligations. And I want to explore that just a little bit more. Our LLCs in Wyoming do have pretty minimal fiduciary obligations as they are, but there are some that, and maybe I'm stuck in an old mindset, but there are still obligations that need to be followed. And one is this tax reporting. Obviously, the second is some sort of tracking membership or mechanism regarding whatever ownership rights exist. And then a third one that comes to mind very easily is what asset is there. Now, the asset may simply be a code, as I've had explained to me, but there are some very basic fiduciary obligations that go along with being any type of entity that's trying to seek recognition and, more importantly, liability limitation. So just like to explore that a little while we got time.
Thank you, Representative Greer. Mr. Wright, thoughts?
Yeah, Representative Greer, that's a really important point and something that we're taking into consideration. Our sense is that a nice path forward or an appropriate path forward would be to preserve the things that are necessary or mandated in other parts of the LLC Act, which members that want to put together a DAO would have to abide by and agree to, while at the same time capturing the spirit of what these folks want to do. So in general, I think unlike, let's say, a more traditional partnership, people are hoping to form an organization with a limitation of liability, but to operate with a degree of arm's length relationship amongst and between them. And by default, at least as you review the LLC Act, that's not really the spirit of what the default LLC looks like. I think you can obviously enter into an operating agreement whereby you modify some of these default provisions, but it does take working with the outside counsel, experienced lawyers to kind of get to that point. So our concept here is to preserve those important pieces related to tax reporting, relating to ownership structure, relating to the ability to understand what assets may be at issue and have that available to all members, but at the same time, make clear that you don't necessarily need to put together an extensive operating agreement to organize the way that that folks are increasingly seeing fit. at least in the context of these organizations.
Thank you, Mr. Wright. And on that point, I'm going to give Representative Greer a chance to follow up first, although it looks like Mr. Kaufman wants to follow up specific on that. But I think it's important to note that the approach that is being explored is really not to change or erode our LLC statutes for a DAO, but to try to enable them to clearly operate and have definition of how they would achieve what the other objectives are, which I think gets at Senator Nethercott and Representative Greer's earlier concerns, was that they didn't want to grant, this is my understanding anyway, I don't mean to put words in their mouth, but they didn't want to grant limited liability through a corporate structure if they were just a magical creature. We didn't know who was behind it. We couldn't find any of their members, so to speak, or anything along those lines. So I think the approach that Mr. Kaufman and Mr. Wright have been working on tries to preserve everything in the LLC statutes and all of the obligation, and just figure out how we can do that without a complicated operating agreement among the parties, but through statute, which hopefully then meets the spirit of everybody's interests. And I appreciate the work they put into that. With that, Mr. Kaufman, you wanted to probably follow up on that specific answer, so go ahead. And I see you too, Mr. Allen, down there.
Yeah, thank you, Mr. Chairman. I just wanted to respond to Representative Greer's question as well. When I raised the fiduciary question last time, and Aaron and I have spoken about this a little bit, what I was referencing is, as most of you are aware, in Wyoming, we kind of have two primary flavors of LLCs, member managed and manager managed. And the duties that members owe each other in a member managed is by default reduced, as opposed to the duty that a manager owes. So that's the nuance that I was concerned about, Representative Greer, in sort of figuring this out, because what I didn't want to do, and Aaron just alluded to this, is we absolutely want to enable these entities in a way where there's an obligation to track who the members are for just things like that, for tax reporting or whatever the case may be. What I was concerned about was being able to use the manager managed entity structure. And then, a lot of practice now already is to create another LLC as the manager, and you somehow sort of stack these things to try to evade liability completely, or being able to trace who the members are if there was a liability issue. So I don't have a particular recommendation at this point. Aaron, I think if I remember right, isn't yours a member managed?
Yeah. So
Mr. Wright, go ahead.
Oh, apologies.
No.
Thank you very much, Chairman. Yes, we're seeing a couple instances of entities that are organized as LLCs that are member managed. And in effect, that's what some flavors of DAOs are hoping to be. They're hoping to be entirely member managed organizations where the members operate a bit at arm's length, which I think aligns with the spirit of some LLCs. The second area would be one where the DAO is entirely deferred to some algorithmic system, and that's one that will require a bit more thought and inquiry. But that seems to be the two, subparts of how DAOs are beginning to develop at this point in time.
Thank you, Mr. Wright. Mr. Kaufman, anything else to add before we go to Mr. Allen?
No, that was it. I just wanted to state for the committee's benefit that my comments were intended that while I'm hugely on board with this concept, I didn't want us to stumble into creation of an entity that people could really effectively hide behind, and we have no way to track who they are, or if there was liability. So a member managed right now seems to be a perfect fit for that purpose. But again, there's a few things we need to watch for. But yeah, I just wanted to clarify that point. Thank you. Yep,
thank you, Mr. Kaufman. Mr. Allen, go ahead. Are you on Representative Greer's question?
Yes.
Okay, great.
So,
go ahead.
I think part of the thing here is we should separate a little bit the LLC form and the work that Dr. Wright and others are doing to take the defaults in the LLC role and find a nice gestalt template that you can drop in, and the issues of being able to contact and notify and know about the beneficial parties. Because the reality is the real responsibility for that is the registered agent. And I would really like to see, because I don't think this problem is with LLC, with DAOs. It's with LLCs and corporations in general. And I would really like to see something on the lines of a digital registered agent. We already have legislation in place for the Secretary of State to accept things from registered agents. Maybe there's a new form of digital registered agent that does this and keeps this information and makes it keeps it private until it is legally called on under legal processes. But in particular, leverage some of the electronic issues there, because there are some interesting things that Aaron and Michael are talking about. There's this sort of edge of where they want to be member managed, but they also want certain aspects of things like the registry of who gets to be a member potentially be delegated to somebody, because they don't want to necessarily manage that themselves. And it'd be great if a digital registered agent was allowed to keep that list, manage that list, maybe charge from some services for, the intricacies of that, everybody's equity is not, like shares. The advantage in LLCs and what a lot of these DAOs want is micro ownership. It's, 0.001% or whatever of somebody else's shares who works more. So I really would like to maybe keep that a little bit separate. And as we, talk this year about moving forward on the corporate registration stuff, that we consider moving those problems into improving registered agents. That's it.
Thank you, Mr. Allen. And it's
identify myself.
Yeah, this is still Christopher Allen. Yep, don't forget to.
Christopher Allen, Blockchain Commons. I reside in California, but because of the wonderful work of Wyoming, we are legally now a Wyoming corporation, and I've begun forming organizations under series rules, and I will be doing the same with DAOs. Thanks.
Excellent. And Mr. Allen, we appreciate your work since the founding moment, I think, of Blockchain Task Force. You were probably at every meeting since, and you've been instrumental in all of this work that we've done in building this community and building the legislation and governance in Wyoming. So thank you so much for bringing your expertise to all that we've been doing. One moment. Let's see. So, Mr. Allen, I did want to follow up on that, or at least the concept of a digital registered agent or registered agents. This gets at one of the core pieces of the LLC that we have to maintain. And in talking with Mr. Wright and Mr. Kaufman, it seems like certainly in the near term, that's going to be one of the required trades. Is if you want limited liability, then you're going to have someone, and that someone is certainly seemingly a registered agent, that someone will have to have access to your membership.
Yep.
And they'll have to have some type of real time or reasonable time access to that membership. And I think that's part of the challenge in how we frame that statutorily to maintain it. And I don't know that we statutorily will need to say anything about a digital registered agent. I honestly think that when we put this together, if we get it right, it will demand a digital registered agent service, that someone will have to come and fill that role, because I don't know that it will be enabled. So we'll definitely need the API. We'll need support by the Secretary of State. And then it's going to be interesting to see the technology meet this governance model, because these registered agents are going to have to know. They'll have to know who the members are. And if those members are micro members, as you were saying, they're going to have to know that. So that we know on this group that the technology is out there to do that. And then the question is really, do we need to enable that? Do we need to take action as a committee to make that happen? Or if we put it on the books that if you want to be a DAO, your registered agent is going to have to be able to have the information about that micro membership, or you can't do it, then, you know, will the marketplace respond quickly? And I don't know the answer to that, but yeah, go ahead, Christopher. Mr. Allen.
My concern is that, you know, of all of the different aspects of things in laws that, you know, you've been updating recently, the registered agent stuff is the oldest. So they have, if you actually look at the, you know, I'm not a lawyer, so I've only been able to look at some aspects of it, but you know, it definitely kind of implies paper records. You know, there's a bunch of different things in there because it's a very old law. And so I do think it needs, you know, some investigation by the LSOs to go, what do we need to do to update some of those requirements, the privacy requirements. I've also heard from some registered agents that, you know, they'd like, you know, that they're intrigued by this stuff, but that, you know, the practices to date wouldn't necessarily allow them to do it. They think that's their interpretation. I think you are actually correct. We're a lot closer to it than we might be, and it is maybe more of a existing companies doing it the way they've always done it type of a problem. And it may, you know, they may need some competition if they're not going to rise up to the challenge. But I do think there are some minor obstacles there that could be easily updated.
Well, one thing I can say about that, and I certainly don't disagree, it's deserving of an update, but I will also say that it's prime for our financial technology sandbox, where if you've got an idea on how to structure a better registered agent that's running into our rules and regulations or running into statute, that's something where we could work with the Secretary of State's office. And this is kind of you know, if anybody out there is listening and worried about it, we have the flexibility to try and implement new approaches that we could then be responsive through legislation to further implement later. So I think we really have what it takes to get that done, even if we're challenged right now. But we need to explore it. We need to understand if there's anything that's holding that back. Thank you, Mr. Allen. And I saw Mr. Wright's hand back up to weigh in on this further. Go ahead, Mr. Wright.
Thank you, Co-Chairman Rothfuss. So just to emphasize the inquiry that I, along with you know, students and other folks that are assisting with this analysis, we are assuming that the registered agent piece will not be impacted in any type of way. So we're kind of separating the inquiry in case that was of any concern. I just wanted to emphasize that point. So we're assuming that there will be one or more persons that would want to form a DAO under this subchapter. They would file a formal document with the state of Wyoming and secure a registered agent in the state to the extent that they're not residents of Wyoming or couldn't otherwise serve that role individually. And then we'll assume that entity you know, is in existence. How that may evolve, that I think that goes to the previous conversation, but I just wanted to emphasize that.
Excellent. Thank you, Mr. Wright. All right, Senator Nethercott, go ahead.
Thank you. Thank you, Mr. Chairman. Just a quick question for purposes of kind of getting our arms around the issue. Under the case scenarios of which we have kind of heard generally about the need for the DAO structure, and in homage to my great Professor Harvey Gelb at the University of Wyoming College of Law, who was an expert on piercing the corporate veil, and I was his research assistant. What do you think, from the case scenario perspective, from the real life usage of the DAO, how does the concept of piercing the corporate veil play into the on the ground usage of these DAOs? Because to me, I'm seeing somewhat of a disconnect with this kind of fundamental concept in our corporate law. And it might be an interesting way to how we craft the legislation and dovetail it into our LLC laws, is understanding how to unwind it if it needs to be, if that, you know, if that LLC veil needs to be pierced.
Thank you, Senator Nethercott. Who would like to weigh in? Mr. Wright, go ahead.
Thanks so much for the question, Senator Nethercott. These are the types of questions that we're trying to sort through. So some of the knottier questions are questions related to winding down, to being able to access or transfer assets if there is some sort of end of life, for lack of a better way to describe it, type scenarios, or some sort of decision from a court or other tribunal. That being said, there is one nice thing about how DAOs are structured, in the sense that the assets are not custodied by a manager. So they're member managed, and the members, each member individually, unless it has a disproportionate voting weight, does not have the right to transfer those assets unilaterally. So you can almost view the assets being held in some sort of like a very large escrow-like relationship. So no one party will have the ability to direct assets to some third party without the consent of a number of the other members of the organization. And if they try to do that, they will be blocked via the underlying software and enforced via blockchain-based network. So from a segregation of assets related perspective, it's arguable that these structures provide superior technology and superior ways to kind of manage these types of knotty questions. So you're not going to necessarily be in a situation, and I'm sure there could be some limited exceptions to this, whereby one party will have the ability to drain all the assets of the organization or treat all those assets as their own. But those types of questions, piercing the corporate veil, winding down questions, et cetera, are the difficult ones that I think we need to carefully consider. And that's part of the charge of what we're hoping to do over the next couple of weeks, so that we can get a clear picture on that, or at least narrow some of those concerns.
Mr. Wright, really quickly on that, and I see I've got a couple of follow-ups, and I'll go back to Senator Nethercott too. She's probably got more, but just playing off of Senator Nethercott's question, the description of your answer assumes a well thought out, well run, well structured, appropriate DAO. But I think we need to statutorily plan for a poorly run, poorly constructed, thoughtless DAO where they're wrecking the train right from their agreement. And so the question is, how do we not rely on the quality of the DAO agreement as the answer to what do we do about piercing the veil and what do we do about finding membership, so that the statute will be robust and meet Senator Nethercott's interests, whether they did a good job or whether they did a lousy job structuring their DAO. Do you have a thought on that? And then I'll go to, I see Mr. Kaufman and Mr. Allen want to weigh in.
Absolutely. I think, particularly in Article 7 of the Wyoming LLC Act, there's already certain provisions dealing with dissolution, winding up, and claims against the entity. So to the extent that those are already achieving the goals, preventing the poorly formed LLCs, or dealing with some of those end of life issues, they can be preserved. So the idea is to preserve the default rules that work well already, to make sure that there aren't bad actors that are abusing this type of structure, while tweaking some of the other provisions just so that they can accommodate this more member managed structure or algorithmic structure that folks want to engage in. So I think that that's kind of the first step. But again, these are really tricky questions, and that's why we're carefully going through it. And at least we can narrow down the issue so that people can make more informed decisions as to whether or not this makes sense for the state of Wyoming.
Great. Thank you, Mr. Wright. Mr. Kaufman.
I think, Mr. Chairman, and I just wanted to address that question as well, because I've given that particular question a lot of thought. And I'm probably in the minority of attorneys on this point, but I preach to my clients all the time that it makes me cringe when people believe that because you form an entity or file an entity with the Secretary of State that somehow you're automatically afforded liability protection. And that's just not the way it works. And And so I kind of feel a little bit differently about this, that, you know, if you're going to file and form an LLC that's a DAO, I kind of think you're taking the same risk that you are if you're filing a regular LLC. Certainly taking the same risk if you're filing a series LLC, and that's something I wanted to make a comparison to, because in a lot of ways, the protections that we're talking about are no different than someone, you know, operating various forms of series LLCs. And so I think we put the onus back on, you know, on the proprietors themselves to understand what the limitations of the law, what the requirements are. You form the entity, you have to take, you know, whatever that looks like, if it's in some decentralized fashion or not, you have to take the proper steps to protect yourself, you know, in the event of a piercing action. And so I kind of think a little bit differently on this point. I don't think we should treat DAOs differently from any other entity, because we tell entities what they have to do if they want to be protected from piercing, but then we leave it up to them to do it. And if someone doesn't think that they have met the criteria and followed the law, then, you know, they're subject to liability. And so I kind of feel strongly that we need to leave that responsibility up to, you know, the individual proprietors.
Great. Thank you, Mr. Kaufman. Mr. Allen, did you want to add to that?
Yeah, so I'm sort of on a similar vein. You talked about a badly constructed, and sometimes you can end up in situations in these electronic cryptocurrency mechanisms where you can't resolve something. So let's say the group decided that they needed, you know, 55% of the people to vote to dissolve the organization or something. Well, maybe it's 50-50 and they don't agree and it's all locked up. You can't move forward, you can't move backward, you're just sort of stuck. So I know that as someone who wishes to create a company to run these types of things, that, you know, there are various time locks where, you know, if things don't proceed, that in effect it can go to an executor to basically, you know, decide to, you know, what, to act as an arbitrator and potentially close the entity down. And that's kind of sort of related to some of the registered agent stuff. Registered agents do not have a fiduciary responsibility of any form. And I think that, you know, if we were to explore this, you know, a third class of registered agent, the first two classes being anybody can be a registered agent, and then there's the commercial registered agent, that if we had a digital registered agent that could act, you know, in the customer's interest in a fiduciary type fashion, that could be very, very powerful in this, because that would allow for the dissolution and forced dissolution and things like, okay, you know, one of the parties is, you know, has a judgment against them, but they're all the money is conjoined and it has to be pulled out, and something needs to be responded to, that it can be through these time locks and other different types of mechanisms, so that the registered agent can technically do what the law requires them to do. So again, I fall back to at some point, you know, it might be after a time lock, it might be after some delay, it might be after a court judgment or whatever. You know, there are sometimes is a need for a party that is not, you know, the member managed group, because the member managed group is stuck, that, you know, needs to resolve at least the financial side of things.
Good points. Thank you, Mr. Allen. On that point, and maybe this is a question for Mr. Kaufman, is there anything that would preclude a registered agent from having a fiduciary responsibility in Wyoming? It seems like you could make that arrangement, even though that's not a default arrangement. Is that true? How would that work? Anyone know?
I'm not sure that I know off the top of my head, Mr. Coach. I'd have to think about that. I mean, as I sit here right now, I mean, so a lot of times, and again, there are fantastic registered agents out there, but we've definitely seen some entities filed by registered agents where they seem to confuse the role of, for example, an organizer with that of a member,
right?
Versus a director, and how those roles implicate liability for themselves. And so I think Mr. Allen's right. Just by way of them being a registered agent of a company, you're not a fiduciary of the entity itself. You do have fiduciary obligations to the state.
Okay.
and to maintain, records and be available and all that kind of stuff. So I suppose, if the entity wanted to make that registered agent, I mean, because people can be their own registered agents. There's nothing
Sure.
prohibiting that in the law. So if you wanted to enter into an agreement with your registered agent that they are your fiduciary, they're a member of the company, they're going to be on the hook, I don't think that's a problem. It's the inverse, I think, that we should be more cautious of.
Okay, thank you, Mr. Kaufman. Senator Nethercott.
Just a clarifying piece for Mr. Kaufman. And do you believe that the registered agent has fiduciary duties to the state or just duties to the state as part of its statutory agreement, essentially?
Mr. Kaufman.
Yeah, maybe the word fiduciary is a bit strong, but the Secretary of State has the power to audit and view the records of a registered agent at any time. And so it is up to the registered agent to maintain that presence in those records. And so, they do have that ongoing duty. You're right, maybe fiduciary is a strong word.
Okay. Excellent. Senator Nethercott, I'm sorry, Representative Greer is on this point. Go ahead, Representative Greer.
Yeah, Mr. Chairman, I mean, I think maybe we need to move on. We need to let Mr. Wright do what he's working on. I think it's a good path. It's a good way for us to look at it.
Mm-hmm.
Right now in Wyoming, the registered agent has statutory duties. Okay, they may owe a fiduciary duty to their client or to that entity that they've picked up. The registered agents in Wyoming are basically clerical. Some of the discussion that we're having is around them being more managerial. Then we've thrown out numerous concepts here that need to be fleshed out. That's fine. But, we're talking about judgments. Well, judgments with an LLC require a charging order. Charging order is to take an interest in the LLC, not the asset out of the LLC. These are complex legal issues. And that's one of those reasons why I think the path of doing a subchapter and looking at what we can do to accommodate this type of entity is a very good path. But there are a lot of very complex issues we need to work through. And I think as Mr. Kaufman, not to put words in his mouth, said early on, we need to protect the integrity of our LLC laws that we currently have in place in Wyoming, because they have been the gold standard for our state.
Absolutely. Thank you, Mr. Representative Greer. And Representative Greer, we've set aside a lot of time for these first three, because I honestly want to exhaust all of these questions and concerns. I want to make sure that we've had an opportunity to explore these, and that as Mr. Wright, Mr. Kaufman, Mr. Allen, and Representative Olson, the rest of that working group, get to the point where they're drafting, that we don't have any more of kind of these concerns out there, and that we've hit on everyone's concerns. So we're not in a hurry, honestly, to move forward, and that's intentional on this one.
Well, then, Mr. Chairman,
Yeah.
I need some sort of bullet point or guidance here.
Sure.
Because this is a type of discussion in which I need to follow along with the statutes, draw upon my experience, and if we're going to do this. And so, yeah, all right. I've got to drop off at 10 anyway, so it's fine.
Okay, thank you. Senator Nethercott.
Thank you, Mr. Chairman. I think to Representative Greer's point, sensing his frustration just with the conversation and the dialogue, despite contrary belief and having been on this task force for years now. Yes, that was passive aggressive.
You've been here for a long time.
Carried a lot
and
of
I thank you for it.
Thank you, Governor. Thank you, newspaper. Thank you, committee. Regardless, this committee is a little bit different, and a lot of it is just kind of throwing out ideas and cussing and discussing for purposes of some of these other groups to go back and work out pathways. So it feels different, and I don't think a bill draft is going to come out like in a normal committee where we would say, I move to draft a bill on this topic. I think right now we're still working at those details, and as we heard from Mr. Wright, Professor Wright, that he's working with his brilliant students as well, and with a couple of the working group, and hopefully in our next meeting, there'll be something more definitive for us to review in writing to walk through. But I'm hoping to get some of these concepts out there for those brilliant minds to come together and think about those pieces. One, so piercing the veil, kind of this interesting new concept associated with the registered agent, which is coming from lay people as non-lawyers, but certainly interesting. So it is really the purpose of the creation of this DAO is for the non-lawyers, right? It is for the people who are asking for these entities that these questions arise. And so interesting for the working group to kind of work through and consider. But to Representative Greer's point, nothing Nothing too exciting, I think, is going to happen this morning on the topic other than discussion.
Yep. Thank you, Senator Nethercott. And agreed. I mean, we definitely take a deeper exploration because we're typically forging new territory on these things, and we need to understand them to get them right. And I appreciate Senator Nethercott's point because that's typically how we've done it in the past. And I do absolutely want a working piece for the next meeting, whether that's bullet points of how we'll draft it as a drafting guidance, and then the case studies, or whether we feel comfortable putting together a rough draft of legislation. We probably want that, or we certainly do want that for the next meeting. We'll have something that's written up that we can go through, but I want to make sure that we've got everything on that list, and this is a great opportunity to do that. Thank you, Senator Nethercott. Yeah, Representative Lindholm. Oh, you go ahead, Representative Lindholm. I see you, Joel.
Thank you, Mr. Chairman. And I just wanted to mention that there are a ton of different issues here as brought up by the good chairman of Judiciary, the good country lawyer, all of those folks that deal in this practice. And I'm not going to begin to even understand a quarter of it. But Chairman, you had mentioned what I deem as a vehicle earlier. And that's our FinTech sandbox. I think that would probably be the most appropriate place and the appropriate way to handle DAOs is to allow the FinTech sandbox to play in this area by allowing people to apply with the Secretary of State, explain exactly what they're going to do to those folks that actually have to audit these types of entities. So that might be, just to drop that little nugget, I think that might be the most appropriate way to handle this as it stands right now, because the reality is, as we attempt to be ingenious and think of new ways to do things, the reality is we're politicians. The real genius are those that are testifying to us in the form of Mr. Wright and Mr. Allen. So that might be the most appropriate way to handle it. Let them figure it out for us, and then we can change the law how they however it works.
Thank you, Representative. And again, one of the things that this committee, the task force, has been over the years is nimble in terms of pass a piece of legislation that's maybe 90-95% there, see what our challenges are, what we haven't gotten perfectly right, and then come back with a fix the next year after we start implementing it. And it does seem to me that with DAOs, we're coalescing around some key concepts that are going to work. And then maybe there are some edge cases that we're going to have to come back and revisit, or maybe we don't get it precise, but we've got exceptional people engaged that will be experiencing it. You know, Mr. Kaufman will probably be the one setting up those DAOs, helping people with it. Mr. Wright will be engaged. So we know that this is the crew that will actually directly be affected and be able to come back, give us feedback on that. Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. So just to make sure it's clear for the committee, and I'm tracking it, because I think I'm tracking with Representative Greer here that this is, the third intellectual conversation we've had about it. And at this point, what I want is a bill draft in front of us. And whether that is everything it's supposed to be on the onset, we don't know. But I think having that, and I understand you, Mr. Chairman, that at the next meeting, that's what we're going to have. And that way we have something to substantively talk about, whereas we spent how much of today talking about registered agents. Is that going to be part of the bill? Is that going to be part of the conversation? I don't know. But if it's not, then we can move on from that and hone in and focus on this topic and decide what we're going to do with it. And I think this committee has to buckle down for that. Whether you're going to support the idea of the creation of a DAO or not is fine. You can vote on legislation when you want, but I think at this point in time, I just want to be very clear that we're not just going to keep talking about it. We're either going to remove it as a topic, or we're going to have a bill, and then we're going to talk about that bill. Is that my understanding, Mr. Chairman, of your direction?
Mr. Co-Chairman, I believe so. I'd definitely like to see a bill draft, but Senator Nethercott wants to weigh in on the point. Go ahead, Senator Nethercott.
Yeah, thank you, Mr. Chairman, and to both of my chairmen in response to mixed messaging and perhaps calendar issues. So what I heard from their Cardozo Law School is that they were working on it. We'll have something in a couple weeks, including with the working group of which the co-chairman is on. So wondering when you're going to have something written for us to return to the committee, working group chairman.
Mr. Co-Chairman, go ahead.
Yeah, thank you, Mr. Co-Chairman. So yeah, that's exactly what I'm asking the committee about. And the reason why I wanted to have a series of these intellectual conversations is to understand whether there is an appetite, one, for this. And I believe that there's differing opinions. I think we're at a stage now where that's what I'm communicating to the committee. Senator Nethercott, is that I would like a bill draft. So that I believe I'm now tracking with my co-chairman, which is also important to me. So at this point, what I'll do is circle back with that working group, and the hope is to definitely have something legislatively in front of you that you can review, whether or not it encompasses everyone's opinions and ideas. That is yet to come, because it sounds like this is a lot of spaghetti at the wall, in my opinion. We're kind of all over the place with it, but we'll begin to hone it in, so you at least have something substantively to look at. That's my goal.
Senator Nethercott, follow up. Okay, and I'll say, we have this next meeting theoretically scheduled October 22nd and 23rd. There's some really challenging scheduling around the time of the end of October, but we've already started talking about it and recognizing that we've got a lot of work between now and the next meeting, particularly with DAOs, and I think we'll have the same thing you'll find with digital identity. Those dates just don't seem realistic anymore, and that they were set there so that we could try and kick bills over to all of our standing committees. We were trying to get our last meeting in before all of our standing committees. And I think we're going to have to surrender that goal, honestly, Mr. Co-Chairman. We've had a little conversation about that, which provides us with more flexibility and more time, but then challenges us because we won't have access to we typically work with corporations, Judiciary Committee, and Minerals Committee. And we were trying to get in under the wire of all three of those. So we'll probably reschedule. I'm almost certain we'll reschedule that October 22nd and 23rd meeting to a later time, which will give us more time to ensure that we've got a bill draft ready to work through at that meeting. So more to follow on that, and we'll try and work with everybody on scheduling that so that it achieves those objectives.
Yeah, Mr. Chairman, and
go ahead.
That's a good point, because I think our biggest holdup with that process was minerals, and the fear of the Title 13 bills that we had to shepherd over to them. But we're going to have some discussion, I think, on our agenda about that. But I think we could definitely move that out further. And that's a good clarification for the committee as to why you don't have bills in front of you today. So thank you for clarifying that.
Thank you, Mr. Co-Chairman. And I think we'll be fine on the ones that need to go to minerals. Will probably be sufficient. I've talked with Chairman Greer about that, and hopefully we're clean to just be handing off after our discussion in blockchain, handing off those tasks to the Minerals Committee, and we'll visit about that. It doesn't say in statute that we have to. It says that we need to work with the Minerals Committee to make sure that if it's Chapter 13 or Title 13, excuse me, that Minerals Committee has the option to basically work that as a requirement under statute. So we can work with Representative Greer on that. Representative Lindholm, go ahead.
Thank you, Mr. Chairman. I just wanted to throw out a reminder that Joel Revel had a comment about a half hour ago, and I think we ended up steamrolling him the way legislators will. So I would like to call out Mr. Revel.
Well, thank you, Mr. Representative Lindholm, and Mr. Revel. The floor is yours. Sorry for that.
Thank you, Mr. Chair. Thank you, Representative Lindholm. I had a question that goes back a little while ago before we were getting on the topic of momentum and closure. So I'm sorry to sort of reopen another question.
No worries. No, that's just fine.
Thank you. This is less from a legal perspective, more from a practical private sector perspective. And just thinking about if we are, as you said, Mr. Chair, forging a trail, I think the reason we're doing that is because we recognize that innovation is being pushed offshore right now with some of these vehicles, that there's potentially an economic development opportunity here in Wyoming. My question is to Mr. Wright, Mr. Allen, Mr. Kaufman, is there an issue that we will struggle to overcome at a federal level? The sort of lack of legal clarity at the federal level, the enforcement actions that are still, sort of the SEC fighting the last battle that are underway. Does that put a cloud over our efforts here in Wyoming? Thank you, Mr. Chair.
Thank you, Mr. Revelle. Anyone want to respond to that? I'm happy to as well, but we'll go to Mr. Wright, and then I see Mr. Allen as well. Mr. Wright?
That's a great question. I think the approach that we're taking here, whereby it would be a subchapter of the LLC Act, should narrow some of that concern. So any of the interests in the DAO structure would be in effect and legally an interest in an LLC. And those, the classification of those interests, there's quite a bit of case law, I'm sure, in Wyoming, as well as in other states that have comparable laws or can be examined by way of analogy to deal with some of the issues, at least as addressed by the SEC, which would come down to classifying the interests. So if interests in the DAO are represented as a token, would that token be a security? Would that be a commodity? Would it be something else? So I don't think it should rub up too closely against the federal issues that are getting sorted out by the SEC and federal courts and otherwise. In fact, it will probably be informed by that effort. There's obviously other issues that may come up, particularly as it relates to blockchain technology, that could include some guidance or legislation potentially related to compliance-related issues. But at the same time, I think that those would just get grafted on top of this. But I do think, and that's what I think could be potentially attractive about this approach, it takes the benefits of what we have with these very flexible structures in the form of LLCs, and we could, and we're aiming to propose some changes that will just make it easier to set these up so that some of the innovation that you mentioned before can be captured here, in Wyoming and across the US, as opposed to in other jurisdictions. And I personally think that that's a huge opportunity, because these organizations are hoping to be global in nature. So there's not going to be multiple jurisdictions where you set them up. There's going to be one. So I think what we've seen, particularly with internet or digital technology, there tends to be some sort of power law effect whereby one ecosystem kind of captures the lot of the value. And I think here, and ideally that would happen in the US and in particular in Wyoming. So why go to a foreign jurisdiction to set up one of these entities if you want to set up a global organization, as opposed to just do it in the US, where that you have fair laws and courts that can administer disputes and practical people that can resolve any issues that come up.
Thank you, Mr. Wright. Appreciate that. All right. Any further discussion? I'm sorry. I apologize, Mr. Allen. You were up next. Go ahead.
Yeah, so I concur with Dr. Wright on a lot of the different aspects that he mentions. I mean, just you can create an LLC now that will violate federal law or SEC regulations or whatever. So, our hope is that the template will, avoid the kind of known problems in that space. People can still modify the template and do things that would be against SAC or fall into token issues and things of that nature. But we can at least help avoid the major pitfalls, make it easy, etc. Separate, though, from what he said, that is still my biggest concern, and this is not just DAOs, it's just in general, all of the corporate entities that we have that use these digital technologies, is that we have this ongoing problem with banks. And I really appreciate that, we've got Kraken and Avanti and others, doing, the cryptocurrency banking services, but access to the regular system of fiat is the major problem for these entities today. And other countries, in particular Estonia, again, you can, as an American citizen, get an Estonian e-residency, which really is kind of a form of registered agent in Estonia. That's what it really means. And you can have a company there in less than a day, and within 2 days you can have a bank account and a merchant credit card account and start doing business all throughout the European Union and every country that is associated with the European Union in 2-3 days. So they're a major competitive force. Other countries in Europe and sub countries like Scotland are looking at, oh, we ought to do what Estonia is doing. It's doing such a great job for them. So we still have that problem to overcome.
Thank you, Mr. Allen. Anything else addressing? Yep, go ahead, Mr. Kaufman.
Thank you, Mr. Chairman. I just had one quick comment, and that was, thankfully, in the realm of entity formations, that's one of the few areas in all of this that states really do have exclusive control. And so I have a lot of comfort with that. Now, obviously, what people do with those entities and how they monetize or how they raise capital, that's a whole different story. Those activities are regulated at a federal level. But with respect to the entity creation itself, that is something that Wyoming can dictate, and we do have authority over. So in that vein, I think we have a green light.
Thank you, Mr. Kaufman. Anyone else want to weigh in on this topic? Okay, and more broadly, I think we've had a thorough conversation on DAOs, but are there any other points, any other questions, anything else that we want to make sure that the working group is considering as this legislation, talking points, and case studies are being drafted for our next meeting? I don't see any. Mary Beth, do we have any other public testimony? Representative Greer, were you chiming back in to weigh in, or you good?
Mr. Chairman, we do not.
I just went to get coffee, Mr. Chairman. So.
All right, excellent. I'm happy you have it, and I need to get more in a moment. Okay, nothing else on DAOs then. We are good. So thanks, everyone. Thank you, Professor Wright. We appreciate your work on this and joining us. Thank you, Mr. Allen. Appreciate your work on this as well, and members of the working group. Next topic we are going to talk about, and I think it's going to be brief because we're kind of tying things in elsewhere, is going to be the KYC AML portability. We'll run through that topic. It will take substantially less time, I'm confident. And then we'll have a break before we come back and look at digital identity. So with that, our KYC AML portability has been shepherded by Representative Lindholm and Ms. Long. Ms. Long, she's in and out today. She's got some business-related meetings, and unfortunately, she can't be with us at this exact time. Hopefully she'll join back, but Representative Lindholm, you want to give us kind of a 30,000-foot overview on the KYC AML discussion, and
Certainly.
Then tell us where we're at. Go ahead.
Yeah, thank you, Mr. Chairman. The KYC and AML comes about from the BSA, the Banking Secrecy Act of, I think, 1971, I think is when it came about. And that is a federal law. And then it was amended under the Patriot Act, or the misnamed Patriot Act, I think is a better term for that, where they actually expanded the authority of KYC and AML. Is basically the federal right to be able to look at your funds. Basically, anytime you get a check of $10,000, you deposit that, or you send someone $10,000. That's an investigatory mark, where your own bank sends in a notice to the federal government saying, hey, you might want to look into this. That happens every time. So every time Senator Driscoll buys cows, every time Chairman Olson buys new couches, every time that, and the list goes on. And so couple that with how we are operating in 2020, if you can imagine a law that was written in 1970s, 1971, and then amended under the Patriot Act, how that works in 2020 is the simple answer is it just doesn't. It doesn't work. Under the recent PPP program that came down from the federal government, even the big banks were telling the federal government, we need relief from KYC AML. We can't get these funds out. We can't get it done because of the standards that are existing in place. And for those of you that have never done this, but I suggest you do, if you've never signed up for an account online, whether that's an exchange or just a banking account, it is pretty wild what you've got to do. Essentially holding up a piece of paper next to your head with the date written on it and your ID card in the other hand, and sending that in as a picture, and then you got to, it's a lot. It's much more than you would typically expect, considering you're just signing up for an account. And so, while we certainly want to protect our consumers and whatnot, the goal of this working group was to find out if there was a way that we as a state can extract some of our rights out of the BSA and make it easier and better to do business in the state of Wyoming. The problem is unlike the Federal Meat Inspection Act, which we have thoroughly bastardized in the last year, and other such laws, the Uniform Security Act, those types of things, the BSA is actually written pretty well. And so there's not really any holes there. But I do think that Mr. Chairman, I do think there is an opportunity there. And I do think there is a way that we can do this, because the reality is, Mr. Chairman, we don't want to put our existing banks in jeopardy. We just want to make it easier for our existing banks to be able to do business in the state of Wyoming. And so with that in mind, we've got to work with the Federal Reserve. We got to work with these federal agencies on doing that. And just like the topic before, I do think we have a vehicle to do this, Mr. Chairman. And I think the best vehicle to do this would be under the FinTech Sandbox. The reality is the FinTech Sandbox gives authority to the Division of Banking and the Secretary of State's office to look at state regulations or state laws and possibly waive them for companies that have a new innovative way to do those things. The problem is that does nothing for federal law, and nor can we change federal law. But I think, Mr. Chairman, the opportunity presents itself that the Division of Banking, working in concert with an established entity in the state of Wyoming, as the law calls for, might be able to open up that discussion with the federal government and possibly get them to relax some of their regulations for the effort of a first try to see if this is possible. So, Mr. Chairman, I know Ms. Long has studied this hard, and I've looked at it quite a bit. I hate the BSA. Reading that thing is horrible. I just can't find holes. I think the best methodology for us moving forward as a committee, if the committee's up to it, obviously after we have some discussion around this, would be to specifically amend some language into our existing Title 40 FinTech Sandbox. And I think there's real opportunity there. I tried to find in Wyoming law, where anything would exist in regards to anti-money laundering or know your customer. And the reality is it just points at federal law. So it's gonna try our LSO attorneys in some pretty creative language. But I think those guys are up to the task. They're pretty sharp. So that's pretty much it. There's the rundown of KYC, AML, and the BSA, and why they're horrible.
Great, thank you, Representative Lindholm. Any questions or discussion for Representative Lindholm? Representative, do you think that we need a statutory change to allow for the sandbox to be employed on this, or did we already cover the necessary areas of the banking statute with our FinTech Sandbox, so that if somebody wanted to try and if some of our state chartered banks, for example, wanted to try and work together or share BSA services, they would be able to do that. What do you think about that?
Mr. Chairman, in my reading of the FinTech Sandbox, I don't believe they have the authority as the language currently stands. As an example, under 4028-104, the Financial Technology Sandbox application and standards for approval, a person shall apply to the commissioner or secretary to make an innovative financial product or service available to consumers in the Financial Technology Sandbox based on the office that administers the statute or rule or portion thereof for which a waiver is sought. The KYC AML standards are somewhat administered by the commissioner, but the majority of those standards are administered at the federal level. So I think it's kind of a whole, and then on top of that, all regulations and statutes that the statute speaks to as far as waivers would be at the state level. So I think we've got. I don't know that it would be a huge amendment to the bill, but I think it opens up an opportunity for a commissioner, really the expert in this area, to work with industry on figuring out this problem.
Great, thank you, Representative. And I think that's something we should try and explore then. And if there are some tweaks or changes to our FinTech Sandbox that are deemed to be necessary, maybe we reach out to the Division of Banking and see what they would, if they had an applicant come along and say, hey, we want to create an organization that provides for portability of KYC AML. Can we do that? Have them work through that scenario and figure out what would stand in their way from trying to put that in the sandbox, and then on behalf of that entity, work with the feds to do so. So I think that's a good path forward. With that, I'm going to see if there's any questions from the committee, then I'll go to Mr. Allen. Any questions for Representative Lindholm from the committee on KYC AML portability? All right, with that, let's go to Mr. Allen. Go ahead, Mr. Allen.
Yeah, so I agree with Representative Lindholm that the sandbox would be of help. The particular area, I want to make sure we're kind of in alignment, that feels like the sweet spot is that I've had several attorneys, and they may be wrong, tell me that that the fact that banks are not allowing KYC information from another bank to be used in their bank. So let's say Wells Fargo, giant bank, I have a 40-year relationship with, or whatever, will not give, nor will they accept any other information from other banks. And so I have to give it to every single little tiny bank, including my little tiny bank in Cheyenne, and who I have much less confidence will be able to secure my data. But what I've been told several times is that there's no rules that say that they have to do it absolutely personally themselves. They do have to say that it was done. Two, the issuers are going, but well, we don't want to give it to another bank because we might have, liability and, from you if you screw this all up. So if there was some kind of legislation that basically said, hey, a Wyoming bank can rely on the KYC of another bank that they have a relationship with, and that relationship can include, limiting the liability of the abuse of that information by the receiving party, or put the liability on the party that's the relying party, would solve a lot of problems, at least within the state of Wyoming, where we don't have to give KYC information to every bank we have a relationship with in Wyoming, but potentially to one. So I thought that was a sweet spot. I didn't know if that's exactly what Representative Lindholm was speaking.
Thank you, Mr. Allen. And I'll go back to Representative Lindholm to respond if you have any thoughts on that.
Mr. Chairman, I very rarely know what I'm even talking about myself. But yeah,
I've noticed that it's true, but we appreciate it.
Mr. Chairman, Mr. Allen's spot on. I mean, the reality is it's going to take a considerable amount of maneuvering in this space due to how federal law works. And very rarely it's really going to be pretty tough. I think especially considering that we now have some of our new state charters going for federal approval. I don't think it's appropriate at this time to move forward with anything drastic. I mean, if it was up to me, I would run something that was, if it was solely up to me, I would run something that completely violated KYC and AML under the BSA, because it's just a racket. But we've also got to protect our existing institutions. These community banks have kept Wyoming alive and well for quite a long time, and they're valued partners of our communities. So we don't want to mess with those guys. But I will note that, Mr. Chairman, I don't know that I've ever said don't mess with banks before, but I'm saying it now.
Thank you, Representative Lindholm. Yeah, we're at an interesting time where we want to make sure that we have the ability to follow through with the things that we've done without rocking the boat quite yet, but then we'll rock it again later. And along with regard to the question that Mr. Allen just mentioned, I think it's an interesting question about the liability, and with the idea of the fintech sandbox, Representative Lindholm, I wonder how that plays out. We definitely have surety requirements already in the fintech sandbox, where if it's Division of Banking, for example, they would be required to assess the potential risk and have the entity that was engaged in the sandbox take appropriate steps to protect against any potential liability they may have through their sandbox engagement. But I wonder if there's any requirements of statutory changes regarding that liability sharing or anything along those lines to capture what Christopher Allen was suggesting. So we might want to take a look at that, as well as you're exploring what needs to change in the sandbox. Maybe think through that liability discussion as well. All right, any other questions or discussion on KYC AML portability? I will say that this, we've had some discussions tying this into the data trusts that we'll talk about tomorrow, and Representative Yin will update us on work there, where you can imagine if we had data trusts in place and they were viable and they were regulated and chartered in some way, that might be a perfect vehicle for KYC AML portability, because they would effectively be regulated to a standard that would be equal to or better potentially than what we're currently holding our chartered banks to with regard to responsible access to and use of that data. So there might be some synergies there that we can look to when we talk about that tomorrow. All right, any more thoughts or discussion on KYC AML? Going once, going twice, gone. All right, Mr. Co-Chairman Committee, it is 10:10 by my clock. Let's take a break until 10:25. Again, 10:25. We'll come back and we'll start talking about digital identity. Please mute your video and your voice, and we'll see you then.
Mr. Chairman, I feel compelled to say my partners always think that I'm drinking a White Claw. I promise it's not. It's just sparkling water, but the can looks like a White Claw. Oh, I can't hear you. You're on mute.
All right, we still need a couple more members. We need Senator Nethercott, Representative Yin, and let's see.
Caitlin's here. I'm back.
Hi, Caitlin. Welcome back.
Hello. Thank you. Sorry, I missed all that. What did I miss?
It was great. We talked a lot about DAOs, and I think we
DAOs.
arrived at a very good place with DAOs in terms of direction.
And what is that to go with the LLC law?
Yep.
Awesome.
And so we'll
That
try and
makes
get
sense.
some legislation drafted for the next committee meeting that we can consider, some case studies, some talking points. Yeah, I think we're in a good place there.
Yay. Okay, cool.
All right, Senator Nethercott will, I don't know if she is out there. Okay, well, let's get started. The next topic for our consideration, and we'll have some good discussion on this one as well, is our work with the Digital Identity Working Group. I circulated a document yesterday to the Select Committee and to the members of the working group that we can use as a discussion piece. So if you want to bring that up. And Mary Beth, did we get that put on the web?
Mr. Chairman, that is Appendix 3-01.
Okay, Appendix 3-01 on the web. So those of you that are following along at home should be able to pull that up. And I'm going to pull my copy off of there real quick. And then we'll get started. Hopefully everybody's got that handy. Let's see, one moment. All right, so a little brief overview. The Digital Identity Task Force has spent a good bit of time having discussions. We actually have had several meetings since we last met. We've brought on some experts from around the world and appreciate their engagement and involvement. We're going to hear from Dazza Greenwood in a moment, and he's been involved. We've got Claire Sullivan on the line. Let's see, where is there? Scott David up there on the line as well. And so we've had some very good support. Christopher Allen has helped to organize this group and these experts, and I think we've come to a good place. So while we had long conversations, a lot of discussion, worked very hard trying to distill to a product that we can try and bring forward this legislative session, we end up with kind of a short initial product, and that's what I've asked Mr. Greenwood to walk through with us. And so Dazza, if you'll introduce yourself, a little bit about your background, and then we're going to be walking through this Appendix 3-01 as a little concept piece. So make sure everybody's got that in front of them. Go ahead, Dazza, please introduce yourself and the floor is yours.
Great, thank you, Chairman Rothfuss and distinguished members of the committee and invited participants. My name is Dazza Greenwood, and I think you asked for a little background, so I'll take a moment to say I started in state government at the beginning of my career as counsel and then general counsel for technology in Massachusetts in the 90s, and was very active with legislation, including UEDA and other legislation. It's kind of in an unbroken chain to, I think, the innovation that's happening in Wyoming now. But the issues are different now, of course. And most of my focus in my career has been digital identity. That was something critical to solve in order to bring transactions online for citizens within state agencies. And since then, I've split my time at MIT, wearing my hat today, where I run law.mit.edu. That's the computational law kind of think tank at MIT, where we do more research and some teaching and consulting through civics.com. But I always consider myself to be kind of by and for state governments, because that's where I started, and I'm very happy to be with you today. So this work stream relates to developing a definition of digital identity in Wyoming statutes that could be used as a kind of a building block that could be referred to support and reflect more of the work that the committee is doing and across the statutes. And it is, I do believe, timely to have such a definition, because increasingly everybody's operating through our digital identities, right? In commerce, with government, in our personal lives. And yet it's, the legal frameworks have fallen somewhat behind. So the translation to what to expect when we operate through a digital identity, as it were, is still unclear. We hope to start to clarify some of that. So I'm going to share my screen, if I may. Host has disabled attendees.
All right, one
sharing.
second.
Okay. And I'm just going to quickly run the committee, sort of catch the committee up on, there we go.
Try again, yeah.
Can you see this?
Yes, we can.
Okay, so this is part of like a 30-page document that the group has been developing as we've met. And I just wanted to highlight.
I'll say though, we can see your whole screen, and I always find it better if you reshare and do it just to the window. Okay, that will work as well.
Thanks. As interesting as the rest of my screen is, here we go. And so this particular part was at least my first contribution, and it was going through top to bottom the existing Wyoming statutes and the Constitution, just to see if I couldn't highlight the areas where identity, or more rarely, some form of digital identity already appears, just so we can level set correctly. So notably in the Constitution, there's 4 words that really get to identity. It's resident, inhabitant, individual, and citizen. Citizen just comes up in your right to bear arms article. The other ones come up in multiple places. So there's a kind of a benchmark of how do you refer to individual people, humans, right now. There was a lot of things that were helpful, I think, in developing what would be I guess I'd say a proportional and a good fit definition in Wyoming statutes. I'm just going to highlight 2 or 3 of them and then run through the very rough discussion draft that we put together. One of them is that whenever person is defined, and this definition here is in your high-level definitions that define terms that will be used unless otherwise specified across all of the Wyoming statutes. That's 8.1.102. Person includes an individual. And this is not uncommon in other parts of the statutes and the regs and the case law. Individual seems to be the go-to to mean a natural person, a human being who is alive. I thought, although this didn't relate to humans, it was very interesting, your tax treatment, which is, I think, somewhat better than GAAP and IFRS with respect to the definition of intangible personal property. There's something similar, although we're talking about property here, not people. There's something to be learned here. Personal property, it lacks mass, cannot be seen, felt, weighed, measured, or otherwise perceived by the senses. It has no physical existence beyond its representational, beyond what's representational about it. Intangible property's value lies in what it represents. So there's some words there that we thought could be helpful. There's also just a question that we didn't treat in the current draft about, do you really want to scope this so it relates to Wyoming people that are Wyoming citizens or residents or operating in the state of Wyoming or not? So some of the criteria with respect to residents we thought were worth taking a look at to ask whether that ought to or ought not to be part of this. And there's 2 others. Oh, marriage. Genetic is, there's a lot of identifiers, obviously, of identity. But with marriage, let me see if I can find that. It came up, excuse me. This is the last one I'll show. Here we go. this is another way to get at what is the essence of how you legally treat individuals at a very core layer. Obviously, in some of the earlier history, wives were considered akin to chattel or property, and that is terrible. But the usefulness of this is we start to see, as the law evolves, what's different when people are treated as people and no longer as property. And the statutes here kind of highlight that they may form contracts, incur obligations, liabilities that can be enforced against them, that they can sue and be sued. So these are some of the attributes, I would say, of the thing that has digital identity when it's a natural person. So we just kept some of this in mind in the back of our heads as well. And then I'll leave the rest as an exercise to the reader, but you can see our entire document if you like. So taking all of that, we developed, the last thing I wanted to show is it struck us that in terms of what to shoot for, this definition section at the top of your statutes, Title 8, 102, was that this would be the gold standard to arrive at a really good definition. And you'll notice that these definitions are quite short and to the point. They just solve the thing that is needed for a definition to be used anywhere else in the statutes. This seemed to be about right. And you'll note that most of these definitions run between 8 and 30 words, and there's not too many of them. So the thinking was, at least as an initial target, to aim to have an insertion to that section for digital identity, and then to use that definition in other sections to say things about digital identity. Okay, so what might a definition be? Well, personal digital identity is just a working thought. And I should also add that this version is something that the entire working group, I don't even think, has weighed in on. As we got prepared for this committee hearing, Senator Rothfuss and I, and Scott David and I, and Tieme Roguer and some others, just started iterating this document to the point where Senator Rothfuss felt there was something appropriate as a discussion draft to get started. So I hope that other committee members will weigh in with their views, and they may differ from this first attempt. But the defined term might be personal digital identity, and we could define it as it is the, I'll read through self-sovereign for the moment to see just the essence of it, intangible digital representation. And then we have this phrase of, by, and for, and then an individual, and through which they intentionally communicate or act. So just to break that down, we're taking best of intangible and identifying as digital, and that it's a representation, and now of, by, and for. So there's a lot of profiles about us, dossiers about us being compiled all around the web and the world that are about us. But what we're trying to say with this definition, which is that of a person, is that this is their identity, and it operates, from them and for them and by them. Individual, we think, you could say natural person if you wanted to get very technical. It seems like individual is well understood in Wyoming law as being a live human being, and then through which they intentionally communicate or act is just intended to get to when the intentional is critical here. So there's a lot of accounts and artifacts of accounts and functions and systems that may be doing things that are associated with a person. We wanted to identify that in this definition that that there's a direct kind of linear connection between the live person and they're operating through, like, deliberately, this digital identity of theirs. And it's not something that the chain of automation and autonomous actions is not so attenuated that it can no longer truly be considered like theirs for purposes of their identity, at least. Leaving aside things like automated stock trading or other systems people may choose to use, it may not be their identity that we're getting at. So we did a parallel construction with organizational digital identity. and then included track to the standard wording in the statutes. It's a representation of by for corporation, business trust, estate trust, partnership, limited liability company, association, joint venture, governmental agency, public corporation, or any other legal or commercial entity, and through which it intentionally communicates or acts. So why would you define this? Like, what's the purpose? Part of the thinking here was, like, there's a lot you can do with digital identity once it is a defined term, to be sure. Something that we felt would cause no harm and yet would also be useful is inspired by Title 40 and your Uniform Electronic Transactions Act enactment. And in that, that's more narrowly related to electronic signatures and electronic records. But the underlying rule of law is known as attribution. And that's basically, how do you attribute an electronic signature or record to a person that can sue and be sued? I was on every drafting committee meeting of this, of the UITA working group in the 90s, and there were quite a few of them. This was heavily negotiated and reflects basic principles of common law and general commercial practice. And it doesn't say you need a private key. It doesn't say you need a particular implementation. It is very definitely technology neutral. And what it does say is that the act of a digital identity is attributable to an individual if it was the act of the individual. And now, how do you know if it was or not? And that's what you argue about potentially. The act of an individual may be shown in any manner, including showing the efficacy of any security procedure applied to determine the individual to which the electronic record or signature or other act was attributable. A security procedure absolutely could be public key based. It could also be other credentials or other forms of authentication. And you don't even necessarily need one. You just have to be able to demonstrate that this person did that act. And finally, with the parallel construction for organization, and then you come to, well, what does it mean if a person acted or communicated through a digital identity? This again is derived from UITA and the rule of attribution, and the effect of a record or signature or other act attributed to a person under this, the prior two sections, is determined from the context and surrounding circumstances at the time they did it, including and otherwise is provided by law. So are you necessarily creating a contract? Well, maybe. Were you 12 years old at the time? Maybe it didn't form a contract. Was it a fraudulent contract? So all the underlying substantive law still applies. All we're doing here is as narrowly as possible, getting at creating a space for digital identity. And I'll just close by saying, why do we care so much about this right now? Well, Wyoming is demonstrably a leader in legal reforms and legislative reforms. I think broadly, I would say that assist in transition from the industrial age to an information age. And there's still a gap in our legal frameworks necessary to make that transition elegantly. Some of that relates to people and citizens who, under our constitutional scheme, are very important entities. It is citizens that must consent to be governed, for example, and who are the source of sovereignty. And there's no place for that in cyberspace right now. Cyberspace now is more like living between a public sidewalk and a retail store. We don't have anything like a home. We don't have an anchor from which we ever could express consent, despite the fact that the way things are going, we're going to be expressing consent and everything else through digital systems. We already are partially, and that's going to be ever more complete with every passing, year and month. So the part of the idea here is to create a definition that can serve as that home base for people in the digital world. And then you can use it as a building block as you build out the rest of the statutes. So I think, and then we have some highlighted questions here, which I believe Chairman Rothfuss will walk you through, but I'm happy to take any questions as well. And I look forward to hearing the discussion. Thank you.
Thank you, Des. That was great. I'm going to layer on just a couple of additional thoughts, and then we'll go to questions. The first thought is there are a lot of trade-offs with anything that we chose to do here, and we struggled with a lot of decisions, but this is where we came to, and it certainly a great place to start the discussion. You see that we intentionally separated personal digital identity from organizational digital identity. That was a struggle on how we would do that. They don't necessarily have to be separate, but we anticipated enough difference in the handling of a personal digital identity, which represents the individual, we started with corporate digital identity as the concept, and we decided that was a failed phrase and wouldn't capture everything we wanted, but that's kind of the concept, is corporations, entities, legal entities as organizational digital identity that would then be treated and managed differently. And we thought setting that bright line from the beginning so that we could handle them differently as we built would be the appropriate path. And this is honestly, in my view, going to be kind of a challenge in some ways to maybe sell the legislature on, why we just want to come with a definition and enabling that definition, right? That's all this does. We set up definitions that create a foundation, and then we provide links into UITA so that those definitions are effectively substantiated within statute. They have legal standing. And that's the first step. We don't necessarily want to layer on all of the things that you can do with it, because getting this first step right is essential to everything that comes along afterwards. Our concern that Daza and I and others have discussed is, well, is that going to be enough for the legislature to think, all right, well, this is worth doing? And what's the killer app here? What are we trying to accomplish if this is largely just a definition? So that's something I think, I want us all to discuss and talk about that and understand that we can't accomplish everything in the first bill on digital identity. Nobody else has statutes on digital identity. And this is a really important thing to get right. So it deserves all of the focus, even though at the end of the day, it doesn't have a lot of bells and whistles. So I look forward to a good discussion. Senator Nethercott, please.
Thank you, Mr. Chairman. I just want to communicate my overwhelming support for the work. I think it's one of the most fundamental pieces, actually, that we can do that affects people's daily lives. And it really is something that needs to be addressed in the law. And I think that this takes just the right bite at the situation, right at our daily lives, in the transaction of business and how we operate in the digital world. And so I just want to express my thanks to the working group, because it's clear to me the level of academic work that went into this, not just kind of big picture concepts and we're trying to shove them into Wyoming law, but actually started with a real study of Wyoming law, understanding federal framework law with UITA and other pieces to dovetail in. And so we're gradually building this very measured approach to our ever-changing daily lives. And I think that's exactly what we need to be doing as a committee. And so even though this isn't necessarily, transformational, it is exactly what is needed and continues for Wyoming to create the space for this and to be on the cutting edge and leaders in this time. So I just want to say thank you for the working group for what is incredible work and thoughtful work and measured work. And I hope to see this move forward.
Excellent. Thank you, Senator Nethercott. I appreciate that. Christopher Allen, go ahead.
Thank you. Thank you, Mr. Chairman. I really appreciate the group that's been gathered together. We have a lot of solid background and diverse perspectives on this. So first, I want to say anything that gets it down into a concrete form so we can begin to discuss the deeper parts of it, I think is great. So thank you, Daza, for pulling that together. The one thing that I'm trying to puzzle out how to address that we had in our discussions that to me was important was missed, and I've added this to the comment in the master Google Doc, is that the decentralized identity community largely got together because of the abuses of surveillance architectures and things of that nature. So this doesn't quite fit what's going on where there are many digital identities for you that were created by others and aren't under your control. So that's why we kind of played around with this self-sovereign identity definition. So one of the consequences of this is that there's all these parties who recognize you, remember you, respond to you, that is where the problem space of digital identity is where the abuses are happening. Whereas this definition is, because it's got the representation aspect of it in I think, which line is that? Someplace I have a cursor. It's the representation of, by, and for kind of implies an embodiment, and there's lots of informal recognition tools, the AI tools, the things that de-anonymize people and their data and all that kind of stuff. So I'm not sure what the right approach is. So I like the definition for sort of the self-sovereign-ish half of personal digital identity, but then there's all that other stuff where there's these digital identities that people have for you that are abused, that aren't under your control, and that's the place where we really want a lot of the legislation is, to prevent people from doing bad things to you. So that's my initial remark. I hope DAZA and also our other members of the Identity Committee might help puzzle this out. Thank you very much.
Thank you, Mr. Allen. And we had a long conversation about that, and I saw Daza raise his hand. So Daza, why don't you address those specific concerns, which I think are very valid concerns, and we will need to find a path forward. But go ahead, Daza.
Thank you. Agree. Very quickly, I got two main action items from what you said. Number one was we attempted to get at the idea of the individual human having real dominion over, or this digital identity being theirs with of, by, and for. You used a word there that is a very good word, and it was in some formulations that a person can demonstrate it's their digital identity by showing control over like a credential that operates an identity or something like that. Ultimately, we kind of washed all that out to make it simpler, but maybe we should think, or the committee should consider inserting the word control somewhere near the middle of that, so that we can show the relationship between the digital identity and the person is that this is the one that they control, not one about them that represents them, but it's other people's control it and so forth. So that word control, I really do believe is missing, or at least the concept is missing, and that would be one of the indicia of what we're talking about. The second thing you said, which is more importantly from a public policy and legislative perspective at this point in history, is what do you do with it? And could people use it to begin to exercise some of their rights, for example? And we've discussed fair information practice rights of, deletion and control, give me a copy, that kind of stuff, CCPA kind of stuff. Our thought was to create a there that then in other parts of statute and other more specific discussions, you could refer to and start to imbue rights and perhaps responsibilities with. So I think that's terribly necessary, but it felt like a bite too much to create a definition.
Yeah, and I'll follow on. I was originally trying to get an or clause in extending the definition to get specifically at what Christopher Allen was discussing, which is the things about me. As there's the me, and then there's the things about me. And after discussion, the reality is the digital identity, if we want to structure it and you think of it as the analog of my identity is the me, and then there are things about me, about my identity. And so the structure we were looking at here is from that standpoint where the personal digital identity is that abstraction of my identity that I control, that is the me. And then we will have to layer on, and we'll have an appropriate framework to layer on the concepts, Christopher, that you're talking about with regard to the about me side of things. And you see that's a discussion point that's actually the number 4 for considerations really is how would we incorporate some of the self-sovereign principles into this framework if we want to add that to the Bill 1.0, and which things would we add and how would we do that? But there really are two ways that you can look at this. One is my personal digital identity the portion I control, or is it the portion I control plus all the things about me, which really are the primary concerns? We know that. But from an enabling standpoint, going with the Occam's razor approach of let's define the core of my identity and then layer on from there where we can separate that which is within my control from that which is about me being gathered and gets us more into what we would do that would emulate CCPA and GDPR and provide those protections of those things that relate to my digital identity seemed like a cleaner, certainly a leaner initial approach. So that was the motivation. Doesn't mean it's the right answer, but that's the motivation behind it. Go ahead, Mr. Allen.
Actually, I would love to hear from Claire first, just in case. But I just want to be in queue because I have a very specific thing on what you just said, but we haven't heard from.
Yep, that sounds great. And let's do that. Let's go around and I would like to hear from Claire. Claire, what are your thoughts on this approach? Go ahead, the floor is yours. And please start by introducing yourself to the committee and a brief background, please.
Okay, all right. So my name is Claire Sullivan. I'm a professor at the Georgetown University Law Centre. I run a cyber research centre there called CyberSmart. So my specialty is digital identity. I did the first thesis in this area, looking at digital identity as an emergent legal concept. Won a Fulbright scholarship to come to the United States. Married my husband here, and the rest is history. I'm now living in the United States. You can hear from my accent that I'm Australian. So I'm part of this working committee, but I didn't see this definition until it was sent to us last night. I was a little surprised when I saw it, but the more I have thought about it, the more I like it. I think it's elegant in its simplicity. I think it's really workable. And I think it's a really good start, and it doesn't get caught up in sort of all the issues of exactly what is digital identity, what is its components. So I'm a big fan, and I like the separating out of the personal and the corporate. The emergence of a corporate digital identity is a really new area, and it's one that's rapidly approaching us. So I think getting ahead of that is important. Christopher, to your point about control, I understand exactly what you're saying, but in many respects, this is out of our control. I mean, I'm really assigned a digital identity for most transactions. That comprises my name and various attributes that apply to me, but I often don't get a choice in what that digital identity actually is. So I like this definition that it doesn't get into that it's really saying that I'm using it, I'm acting through it, I'm communicating it. And as soon as I do that, it becomes the means by which I'm represented digitally. So I think it solves most of the problems without getting into some really difficult issues. But I think the way forward with this is really going to point forward that there really needs to be some specific principles around all of this, of how it's managed, etc. And I think that gets to the kind of concerns that you have in terms of the self-sovereign part of it.
Excellent. Thank you, Claire. Appreciate that. I want to go to Scott David also.
Yeah, I don't have any comments at this time. I mean, I've worked with on the language a little bit with DAZA, and it's moving in the right direction. I think one of the challenges is going to be just in terms of introducing it to folks so they can see it in operation. And this has been alluded to already, is to just provide some use cases, to show them how it would work through and how that would be different than in other settings. But I think the ideas are moving in the right direction, and I think a lot of this is going to be, when you're trying to lead, sometimes you can lead by following also. And so for the state to be aware of what's going on in the out in the larger world within the United States and outside, I think is going to be very relevant to continuing to develop this so that it can be useful. Because my understanding is that this is intended to be something new and innovative. And so to innovate, we need to find those gaps, and the gaps are changing quite quickly. But anyways, I don't have any particular comments at this time, except to say that there's looks like there's good work being done, and I'm plan to continue to help out.
Excellent. Thank you very much. And Scott, I didn't ask you to introduce yourself briefly. Again, a brief introduction.
Sorry.
I know you, but it's always good to do that briefly.
Sorry about that. Yeah, my name is Scott David. I have been an attorney for 30 years in financial services in New York at Simpson Thacher, and then with Preston Gates and Ellis, now K&L Gates, worked in a lot of, basically my entire career I've been putting intangible rights into packages so they can be moved around, whether they're business type rights or tax rights or data rights, individual rights, intangible rights, etc. And so this is, to me, an extension of that. Is what does it look like? You know, the famous painting, "This is not a pipe." Well, you know, it's a realist painting. Well, the question is, what's the difference between the thing represented and the representation? And that's what we're struggling with here. One of the things I think that, I'm now no longer an attorney. I work at the Applied Physics Lab at the University of Washington, basically working on engineered policies. So the idea is to try to take law and treat it as engineering, and rhetorical engineering, in a sense, story building. And so that's what we're engaging in here. So it's my pleasure to be working with folks here. Thanks.
Great. Thank you. Thank you very much, Scott. And really appreciate Claire, Scott, Daza, your work on this, and in joining, and Christopher Allen for kind of organizing and helping to bring this group together. I think we've got a great team that worked on this, and we'll keep working on it. But good job, everyone. All right. So with that, let's see. Christopher, do you want to weigh in now? Okay, go ahead, Christopher.
Thank you. As far as my introduction for this session, if you missed it in the previous, I know some people tuned in just for identity. Yeah. My name is Christopher Allen. I am with Blockchain Commons, which is a Wyoming LLC based on the new LLC laws there. And in particular, I'm a technologist. I'm the co-author of SSL-TLS. I am the co-author and sort of inventor of the Decentralized identifier. I'm the former co-chair of the W3C credentials community, and very involved in sort of human rights identity and digital advocacy and privacy issues and things of that nature. So I am not a lawyer. I'm coming from the technology side, but I've also been doing this for a long time. So, you know, I have a lot of aspects of things. So one of the questions that I have for Daza in this and the other actual lawyers is, you know, does it maybe make sense to sort of carve out to say that, you know, what you know, the credit bureau has for me is not a digital identity and should not be called. I mean, a lot of people say, well, they have your digital identity. They have all this information about you, which may or not be correct, et cetera. Is we be very, very clear that because it's not under my control and because it's, you know, X, Y, and Z, that it should not be considered a digital identity. It is personal identifiable information. But it very explicitly, because it's not under my control and isn't necessarily even fact, it's an assertion that it isn't, and that might address my concern that people are going to try to say all these things that aren't under my control are my identity, when in fact they're not. So I was hoping that might be one way to address my concern and still keep the current definition.
Thank you, Mr. Allen. And, you know, that really does get to the heart of our first consideration, which is the use of this phrase "of, by, and for." And it's precisely that intent that is why there's an "and" there. We actually talked about the "or." An "or" clause would be permissive and expansive, and then we could have had another "or" clause about all of the outside material being part of that definition. With the of, by, and for, the concept there is it has to meet those three standards, and that credit bureau information theoretically would not meet those standards. That was the intent of that drafted component. With that, I'm going to hand it over to Daza, though, to talk kind of more about that language.
Okay, thank you, Mr. Chairman. Couple of quick things. One is, did you notice the way you characterized the credit bureau's profile on us? You called it a digital identity. This is expected. And so that was part of the idea of adding a third word. Not like I'm definitely not in favor of adding words whenever possible, but we tried to make a space definitionally for a term called personal digital identity. You could change that term, but I think some steps need to be made to distinguish this from other identity information that is not this type. The other thing is, I think the addition of a concept of control in a future draft, I think would also be helpful to distinguish between those two kind of situations you mentioned. We certainly don't control our FICO score. The other thing is, where would one make an affirmative statement that like a credit score and the associated information about people is not this? You know, maybe somewhere in Title 40. So as you start to build out what kind of rights, obligations, expectations people might have with respect to their personal digital identity, that sounds like a real good candidate to clarify what it's not. And then in the fullness of time, you know, one may be able to exercise more control over identity attributes, like, you know, akin to fair information practices, privacy laws, identity theft, you know, CCPA type stuff. And you can start to build out what the interactions are between an individual's personal digital identity and data that's about them, which may not be for them. It can sometimes be very hostile. I mean, by the most raw definition, like a special operations team, you know, demographic profile of somebody on a kill list is not their digital identity. It's happening to them. It's hostile. This is not that.
Thank you, Deza. And Christopher, you know, that was one of the reasons why we've got in brackets the terminology that you've pioneered, which is the self-sovereign concept. And the self-sovereign certainly implies control and would capture that. The reason we didn't put it in the first draft is there was a little curiosity of whether self-sovereign is sort of too new of a term for statute, and whether self-sovereign would then somehow need a definition somewhere else, because I don't think we use self-sovereign, to my knowledge, elsewhere in statute. So it was another discussion point that we want to capture that concept and maybe control, since we use that elsewhere in property and it's in statute. I think there's probably case law surrounding it. I'll ask Senator Nethercott for her thoughts on that. But we want to capture that idea. It's just kind of a challenge to capture it concisely. So I like self-sovereign because I know what it means. I don't know if statute knows what it means enough to use it. So that was my thought in the discussion. Senator Nethercott, what do you think about self-sovereign versus control and this discussion?
Well, I agree with Mr. Greenwood that there needs to be added in the concept of control. I do think that can be managed and handled. You know, self-sovereign freaks me out a little bit, just that term, you know, so, but I think this is the right space to bring it in and introduce it into Wyoming statute. There is nothing similar that I'm aware of. So I think we'll have support within the legislature for the term and the concept, and think that this is the right guiding subject matter to bring it in. But I think that there probably will be some initial hesitation too with any kind of terminology associated with sovereign.
Yeah.
The only, you know, just as an aside, the only other time sovereign is used is really in regard to governmental immunity, sovereign immunity, of course, completely unrelated here, but you know, that will be I think the similar concept that people may go to.
Great. Thank you, Senator. Anyone else? Let's talk about the control concept a little bit. I see Caitlin. Hi, Caitlin. Go ahead.
Hey there. Thanks, Mr. Chairman. Yes, actually, Senator Nethercott, you're spot on. The concept of sovereign ending up in statutes, even if it's got the adjective self in front of it, I can understand that may be challenging. Where this concept of self-sovereign comes from is natural law. That essentially it's acknowledging the government doesn't define your identity. So many folks think that because we need a driver's license or a birth certificate, or in the US, a social security card, and that the government defines us, and that's kind of implying that the government owns us. So I think the way to sell this to the legislators is to appeal to natural law, and maybe instead of using the phrase self-sovereign, I completely understand where Christopher Allen's coming from. That is absolutely the phrase that has been developed in the in the digital identity world. That's more of a philosophy than I think necessarily a term. It's almost like, using the term digital asset as opposed to cryptocurrency. It really is the same thing, but there's one that sounds more palatable than the other. And so, we selected digital asset in the statutes. And I think a lot of the Wyoming legislators might like the concept of using the natural law phrase that the government doesn't own you, you own you. And that might be helpful. Thank you.
Thank you, Ms. Long. That's a very good point. And going back to the natural law concept of self-sovereignty, it should be appealing if people don't find some other reason to freak out about it. It's appealing to me. I like the phrase. Representative Lindholm, what are your thoughts over in the House? How is self-sovereign going to play if we have that as part of the definition?
Like a drum, Mr. Chairman. That's going to speak to the heart of my former colleagues. I think honestly it'll go well. My only question in regards to how this all plays out is specifically, where was I, Mr. Chairman? You caught me by surprise.
No worries. I like to do that. When hands aren't raised, it's the professor in me, right? I'm looking at the person who's kind of staring off into space, and I'm thinking, time to call on Representative Lindholm.
Yeah, Mr. Chairman. So on the active individual may be shown in any manner, including showing up the efficacy of any security procedure applied to determine the individual to which the electronic record or electronic signature or other act was attributable. My question would be in regards to the UCC or UITA. How is that handled in regards to fraud or forgery? In regards to how will this work in regards to that person's individual identity when someone has hitched their mules to the wrong wagon, so to speak?
It's a good question. I'll give it to Daza on that one. Go ahead.
Great, thank you. So that was the crux of animating a lot of the debate behind drafting of that clause, as I recall. And so the main fact determination is, was this the act of that person? So you mentioned forgery. You could think of, fraudulent impersonation, that class of kind of identity crime. So what we've set up here, just again extending forward from the pretty conservative rule in UITA, is like a criteria to determine whether something was or wasn't forgery, and that becomes a fact determination. If it was, then it's something that did not, then it would occur, from a different actor and not from that person through at least this formulation of digital identity. And if it's deemed that it wasn't, then the act would be attributable to them. And so they may have the obligation under that contract that was signed, for example. So the idea was to do minimal, or the goal was zero tampering with the underlying substantive rules of law and the current relationships between people, but to enable actions to occur online through digital systems.
Perfect. Follow-up, Representative?
No, Mr. Chairman, I think that's helpful. As long as there's not any kind of conflict in regards to existing law and how we're defining digital identity. I mean, I'm 100% behind what's been drafted here. I think it is a smart move, but it's also, I think you undercut it yourself, Mr. Chairman, as far as what the work of this group has done. This is far more. I think it's far more than just simple definitions. I think this really stretches its legs in the area we need it to. But Yeah, it's going to be interesting to see how it plays out. Throwing in sovereign identity, though, I really like that idea. That'll trigger some thoughts.
Well, it's no fun if we don't trigger some thoughts. Thank you, Representative. Ms. Long.
Thank you, Mr. Chairman. Just to connect a couple of dots as well, the state GOP put out a legislative priorities, and one of which was prevention of human trafficking. And one of the interesting things, so this does play right directly into that. One of the interesting things I learned in working on digital identity at a UN conference a couple of years ago is that the first thing that happens when someone is trafficked is usually that their government papers are taken away from them. And in certain emerging markets, one of the most difficult things that when oftentimes a young girl, but not always, when the victim escapes, is proving their identity again and proving that they are who originally they said they are. This is one of the reasons why this blockchain technology is so useful in the human trafficking world, in especially emerging markets. What's happening is some non-governmental entities are allowing the parents or encouraging the parents to register on a blockchain some identifiable information about their child when the child is born. So that there's never an opportunity or a situation rather, where if they do end up in a trafficking, becoming victims of traffic, that they can't prove who they are. So one of the things that I hated about this, and to be honest, this was something the UN was actually looking to try to fix, is that governments set the identity standards through these definitions. And if someone can't meet those identity standards, they lose their identity. And that's literally what happens to a lot of the victims of trafficking, because they've lost their government papers. And so I like the idea of going down this self-sovereign route, whether we use that phrase or not, precisely because you have to be able, when someone loses loses control of the evidence of who they are, they have to be able to regain that using a self-sovereign technique, a natural law technique, something along those lines. Thank you.
Thank you, Ms. Long. Senator Dockstader, go ahead.
Thank you, Mr. Chairman. I also agree it will trigger a lot of thoughts. My bigger concern is it'll take up a lot of floor time unless we lay some groundwork out in front of it.
Yeah. Thank you, Mr. Majority Floor Leader. Yeah, and I think we can try and do that and just start with some early conversations, talk through with people. That's one of the beauties, I think, of this particular committee, is that we, as Representative Lindholm said earlier today, we've got plenty of horsepower on here, I think, to try and communicate what this is supposed to do, what the objective is, and allow that foundation to be built. So hopefully we'll be able to. And I do like self-sovereign. If it comes down to people uncomfortable with that particular phrase, we look for synonyms, and I think that's acceptable as well. But I think it's a nice starting point. Any follow-up, Mr. Majority Leader? Okay, thank you. All right. Christopher Allen, I see your hand up. Oh, I'm sorry. I'm going to go to Mr. Co-Chairman first. Mr. Co-Chairman.
Thank you, Mr. Chairman. Just wanted to weigh in a little more on the linguistical aspect of this. The lawyer in me keeps going back to sovereignty, and we've said it's going to trigger a lot of people or trigger a lot of thoughts, and I think that's accurate, and it's likely going to happen because you're right, the concept of self-sovereignty or even personal self-sovereignty, that doesn't exist in Wyoming statute. But what is really intriguing to me is that if you look across human history of jurisprudence, the concept of sovereignty is what we use to define our government. So we use to define our state, our nation. When we refer to sovereign immunity, or refer to sovereign whatever, we refer to the government. So I think words matter, and choosing the word self-sovereign, and I don't want to get ahead of ourselves of abandoning that at some point, but I think we really should focus strongly on the concept of self-sovereignty, not just the concept of it, but the choice of words to use self-sovereignty matters here, because it really goes to the focal point of everything that we've been working on, which is a decentralization of how we view the corporate world, of how we view our government world, of how those two worlds interact, and quite possibly even on a much grander scale, how we think about our citizens and our people and how they interact with their government. And so I think just having a much deeper meaning to it, and I really like the terminology self-sovereign. I think that judges, justices will struggle with that concept for a very long time, as the word sovereignty is something that they use to think about the king's deer. I'm excited to see this go forward. I'm excited to actually see the intellectual conversations that will occur, hopefully, on the floors. I also agree with Senator Dockstetter that we're going to have to lay some significant framework ahead of it in order to get this concept from crawl to walk to run. Thank you, Mr. Chairman.
Yep. Thank you, Mr. Co-Chairman. And I'm going to go back to Mr. Allen. And we have public comment also on this topic, so I want to take that, and then we'll have some more discussion as well. But let's go to Mr. Allen first, and then we'll draw in some of our other public discussion. Go ahead, Mr. Allen.
Thank you. So, yeah, I mean, I coined the term self-sovereign identity for this purpose, 5 years ago, to try to start a dialogue in this. And as Caitlin has said, this concept has been brought up before United Nations, et cetera. People have been, struggling. Can't we come up with some other word for it or some other phrase or whatever? And everybody seems to so far come back to it. And I think it comes to the fact that, there are under, UN Charter of Human Rights and things of that nature, there are things that, nations can't do. They can't take away that you're a person. And that's kind of the root of the first principle of self-sovereign identity is that you exist. You are a real person, whether or not your digital identity is all screwed up or not. You're real, and you deserve. You have dignity, and if anything, Wyoming is a very dignified state. So. I would really love to see, Wyoming figure that out. If you can find something better than self-sovereign, I would love to see it. There are a lot of people that are looking for that, especially in more, Europe is struggling with it as we speak. So, thank you very much.
Thank you, Mr. Allen. All right. Any final thoughts or questions before we go to public comment? Seeing none, Mr. Marr, I see. Oh, I'm sorry. I'm going to go back to Daza real quick, and then we'll go to you, Mr. Marr. Okay, go ahead, Daza.
Thanks. Quickly, number one, for what it's worth, I'm very much a fan of the concept of self-sovereignty, and as we've been chatting about in the side chat here, I think it's I don't think it's a new idea. I think it very well reflects the basic social and political contract that the nation, has. It's part of our jurisprudence that sovereignty sources from the people. But then there's a tactical question legislatively of, what do you want to do now? And it strikes me that one thing could be to just add the bracketed terms, maybe take them out of all caps of self-sovereign and leave it at that. And then another thing that could be done is to leave it as is and remove the bracketed term and then leave self-sovereign for another day. Another thing that could be done in either of those scenarios is look at the some of the principles that you, Christopher Allen, and others have started to build out with this more modern formulation of self-sovereign identity, and see whether those might be appropriate for another legislative vehicle in some chapter that relates back to this kind of more neutral definition, so that you're using the attributes on a more general definition and remain somewhat agnostic to how that's going to play out in the legislature or when that would play out.
Excellent. Thank you, Daza. Joel, to you.
Thank you, Mr. Chair. I just wanted to add one thought that as we were working in the subcommittee, that was, this isn't the appropriate sort of foundational level to include, but would just like to plant this seed with the legislators for further consideration down the road, which is I think there is an interesting way that this could tie back to Wyoming and Wyoming residency, Wyoming taxation down the road. If right now there really is, other than a hunting or fishing license, there really is no definition of how you become a Wyoming resident. And therefore the distinction falls back on the state from which someone may be trying to abandon residency. And that's a moving scale right now, and probably going to start moving more rapidly. And we've seen some proposed legislation, for example, in California, which would be taxing wealth with a 10-year tail on it, regardless of where that person domiciled. So I think there are some great applications to build off of this foundation down the road that could be Wyoming specific, and just wanted to leave that thought. Thank you, Mr. Chair.
Thank you, Joel. I appreciate that. And yeah, I think that is a very good use case for identity is residency, and we can do a lot that I think will be beneficial to our constituents if we can clearly establish that, and then we can build other statutes around that and that recognition. So getting at the tax concepts that Mr. Ville was talking about, we can do that with this approach, and I think it would be a powerful tool for our people. All right. With that, let's open up public comment. Mr. Marr, go ahead, and please start by introducing yourself once again. Welcome back to the committee. We're happy to have you here, and look forward to your comments and participation.
Yes, thank you. Can everyone hear me?
Yes.
Wonderful. My name is Brendan Marr. I am an MIT Media Laboratory alumnus from 1998. I'm part of the MIT computational law ecosystem with DAZA. I am a allow mentor, and I own 2 corporations and a series LLC in Wyoming. I'm going to make 4 quick bullet points and a bit of a conversation on what has been talked about today. At some point in the future, I may make a formal presentation, but I want to keep this short, considering that the last committee meeting, I went off the rails. So first and foremost, Wyoming, we all know, has done a tremendous job, but they are suffering from the Goldilocks paradox, because you've solved one of 3 problems. You have assets with identities and keys, but you don't have a way of representing individuals and or entities with digital representation. So that's why nobody is able to come in mass to Wyoming in these new kinds of digital ecosystems. And we'll see that as we work through these issues. The other point is file numbers and serial numbers and entity creation is critical and related to these discussions of identity. And DAZA has put forth a idea of name, rank, and serial number. And this idea of serial number is really important, because serial number is just like a file number. But if we think about these things as things that can persist on a blockchain, and in a way in which you can have that provable by a special kind of blockchain-based registered agent that proves that that identity is on the chain, whether it's for an individual or an entity, becomes really, really important. And it gets to Ms. Long's conversation of self-sovereignty, right? At some point, we need to be able to have an attestation that identity exists and persists in some form. And the most important thing here is the notion that is open-ended, that this persistence has many different forms. So it may be a key, it may be an IP address that persists. As long as it persists, and we have a way of knowing that as truth, then we can connect all the dots. So I believe firmly that the ideas of a blockchain-based registered agent can play a big role in these matters, as Christopher Allen was suggesting, and as I mentioned the last time. But those are my points. But regarding today and today's discussion, I want to make this statement, which is, I think, really salient. And it is something that I've come to observe, which is one of the fundamental problems with the Series LLC, and it is related to individual identity, is that you have the problem where you don't have control. So the question is the asset something you have control over, or is it something you don't have control over? Because ultimately the question is about serving papers. Who do you serve papers on? What entity? And these things are all related. And I know Co-Chairman Olson's concerned that we're not moving quite, fast enough on these issues, but they're all related, and it is really, really critical to spend the time to define them in a way in which is open and allows for us not to shoot ourselves in the foot. Thank you very much.
Thank you very much, Mr. Marr. I appreciate the presentation and the discussion. Questions for Mr. Marr? So with regard to the Series LLC, specifically the last point, you talk about the control aspect and whom to serve the papers on. Tell me a little bit more about what is a solution there, or what ambiguity do you see in place, and maybe a scenario or an example that plays out your concerns.
Sure. I believe one of the fundamental problems is that we have this idea of ownership of an asset, but we don't have the idea that that asset is an entity in itself. So again, we come back to the idea of a representation of an entity, just as we have the idea of a representation of an individual. And these things are the missing pieces, the two missing pieces that we don't have. Once we solve these things, we will be able to have a functioning system. So I do think that I lost my train of thought there, but I'll just leave it at that.
Okay, thank you. And I mean, so what it sounds like really is that you do see our specification of personal digital identity and organizational digital identity as at least moving towards enabling the objective that you're discussing, where there will be more clarity of the entity and its relationship to law, to statute, and to property ownership and other concepts. Is that a fair statement?
Yes, and we are making tremendous progress here, because I think what we've all hit upon is this idea of control. And in all cases, this is the crucial nugget, I believe.
Excellent. All right, thank you. And I see Christopher Allen has a question. Go ahead, Mr. Allen.
Sorry, struggling with mute buttons. So thank you. So I will say that in one of our earlier discussions, we did have the word "and things" in it, and we ended up pulling that out. And it was in regard to things like IoT devices and such. But I will concur that I have some similar problems. So I do have a Wyoming Series LLC that tries to keep all of the different intellectual property assets separate, so that the people who are working on intellectual property B are not liable for failures in Series D or E or whatever. That's what the Series LLC law was all about. But it's really hard to be able to firmly say that this intellectual property belongs to C or E. But the same technology that, you know, I'm recommending that the Secretary of State adopt for use with registered agents and for identifying corporations, which is the W3C Decentralized Identifier Standard, will work for not only that, but it'll also work for things and digital property and whatever, so that you can definitively say that not only is this cryptocurrency belong to a particular organization with a, you know, proof of funds and, you know, proof of, you know, all the same type of proof reserves stuff that the banks are now being required to do, individuals can do and companies can do. Well, we can also do that around the more intangible assets, as well. So I think there's a there that there is this, digital, the party that controls legally this intellectual asset, and being able to identify that and then be able to say, yeah, ever since 2021, when we registered it under Wyoming law, that is now a digital asset. There's also money there where just, like with liens and things of that nature, there can be a small fee for basically registering intellectual property or other different type of thing in this fashion, or register the fact that you actually own that Ring doorbell for a penny, and it doesn't actually belong to Amazon, which is kind of the way it is right now. That you ought to have control of your Ring doorbell, and maybe pay a penny to register it or whatever. So anyhow, I think there's some real possibility.
Yeah. Thank you, Mr. Allen. And we did discuss that. We certainly have had a lot of conversations about the things, the objects, the assets, and the fact that in the future, obviously, they too will have an identity, and there'll be ability to act upon them, potentially ability for them to act. And I think that's something that we need to tackle, but I'm hopeful that can be kind of a next tackle. And I guess I'd ask, is that okay for us to me, right now, the person and the organization are so deeply interwoven with statute and with statutory rights that they make sense for us to lead with. And then the concept of things having identity would be a future follow-on once we get this right. And that's my inclination, but I'm curious, does everyone else agree that that's an appropriate approach, or would it make more sense for us to acknowledge the identity of things, however we want to define things, or whatever that would mean at this time? Mr. Marr, I see you have your hand up, and I'm going to go to Daz after that. Go ahead, Mr. Marr.
I agree to hold off.
Okay. Thank you. Daza.
Thanks. It strikes me that the main thing to avoid in statute is an accountability gap for things with identity that are taking actions that may be creating liability, civil, criminal, other harms. I hate to be a downer because there's a lot of good and latent efficiencies and productivity and benefits to be had the more we enable and use these more automated and more autonomous constructs. It strikes me that the way we've framed things so far, the natural encapsulation of this would be non-person digital identity, because person includes natural people and legal entities, and then the trick would be to ensure that whatever is happening with these things has at least one legal entity that is responsible for those actions, so that there is a chain of accountability. And the story isn't like my lawnmower decided to run over your cat. It had nothing to do with me. Just it has a processor in it.
Right. And Des, I think right now you can you can get yourself almost anywhere you need to be if you were to form an LLC, use it as your organizational digital identity if we get to that point, and then put assets under it. So you can still get most of the way to current objectives for things if you want to through a two-step abstraction, and maybe down the road we can turn it into a one-step as that demand increases and as we potentially see value there. But I agree. I think right now our statute just doesn't necessarily anticipate your lawnmower running over the cat and then being responsible for it. Yeah, Scott, go ahead.
Yeah, I agree with everything that's been said here. One thing we certainly want to do is anticipate that day. One of the constructions that we're using in our work is quadruple A risk or quadruple A threat. And in that we say there's 4 types of threat for humans: attacks, accidents, acts of nature, and AI or ML. And the attacks and accidents can be done by something that has discretion. So a corporation or a human can do things because there's an expectation of a duty placed on them. Acts of nature are things that are harms that don't come from any kind of discretion. And then AI and ML are there on the end because we understand or believe that they are on the transition point between being inert and having discretion. So if you look back at the history of corporations, it's pretty interesting because they're just a bunch of people organized together, but they do have personhood legally. They do have discretion, even though there's no human behind it. And so one of the things for us to anticipate is that corporations are things, they're not people. I mean, yes, by statute, they're people, but they're not people. They're not human people. So we should anticipate that there'll be other inert objects and inert systems that will be given discretion, will have assets, can sue and be sued, all that nice stuff. So we should make sure that when we're doing this with the anticipation of having things be folded back in, that we have that anticipation, that we shouldn't make it difficult for us to then fold it back in. I tend to think that not from a legislative perspective, but from an analytical perspective, all 3 should be done at once. Because from an organizational perspective, we are talking about inventory control numbers. Mm-hmm. Social Security Administration looks at this as an inventory issue. And so there's a reality to that. So anyways, I just want to make sure we don't leave it unattended, even if we don't introduce it in legislation, that it should be something we clearly have a pathway to reintroduce it, because I think we're going to be doing that serially with new systems that will start to resemble corporate type forms and other organized forms that may hold assets and therefore be sued. Yeah, no, thank you, Scott, for that. That's a strong thought, and honestly, let's just mark that also in our minutes, staff, and make sure that we're taking note of consideration for probably next year of digital identity of things and that concept, and we'll start exploring that more and making sure that we're not screwing it up and that we've got a good foundation in place. Co-Chairman Olson.
Yeah, thank you, Mr. Chairman. Just in case anyone thought I wasn't paying attention, that in Wyoming, when we talk about AI, we often think of something very different than artificial intelligence. When I was traveling last weekend to my kids' soccer game, my wife, who teaches in a rural ranch community, reminded me what AI means in our agricultural communities. Just a thought for all of our techies that it's confusing in Wyoming.
We're not talking old school Wyoming AI at this point. We're talking artificial intelligence as we're exploring Scott David's thoughts. Go ahead.
They are seminal discussions, however.
Well said. Who's got the rim shot available? All right, Mr. Allen, go ahead.
Yeah, I think, one of the key things that maybe we're not quite seeing is that one of the reasons why we're willing to give, some kind of personhood to a corporation is because of the registered agent, we're able to see who has control. And we're willing to do some things with digital assets right now because we can know who has control. We can demonstrate it, we can prove it. So for me, if you can't prove who has control of an intellectual property, then it isn't it's an assertion, it's a claim, but it's not an identity. But there are these things that are emerging. So I think if we're very careful in how we talk about that, control ultimately legally ends up to a group of people, a group of natural persons, even if it's through a registered agent and a group of people that have mutually collaboratively agreed to do something together. That's the only reason why a corporation gets these rights. This comes back to that fundamental issue, and what Professor Maher said was similarly there is a trifecta here, or a three-legged tripod is probably a better example, which you already have to a certain extent in the fact that you've defined digital assets. But you've defined digital assets without the ability for people to necessarily prove control, for individuals or corporations or other parties to prove control. Although you do require banks to do so. Thanks.
Thank you, Mr. Allen. Mary Beth, do we have any other public testimony waiting? I see on the list a Mr. Satterley, but I don't see Mr. Satterley in our room. So if Mr. Satterley's out there, now would be a great time to join for public testimony. And Mary Beth, anyone else that we're waiting on?
Mr. Chairman, that was it.
Okay. Well, Mr. Satterley, if you are out there, if anyone else is out there and interested in providing public testimony, please join now. It's almost lunchtime and we'd be happy to hear from you. But with that, we do have just a few more minutes, and I'm sensing that there's general consensus that this is a reasonable approach that's been put forward, and that as a committee, we'd be interested in getting this drafted for the next meeting. So let's open discussion on that. Anything that we would want different from the drafting recommendations that DAZA presented, or any thoughts of what that draft should look like? All right, looks like we're in good shape there. Good deal. Well, let's do this by motion. Is there a motion to direct Legislative Service Office to draft legislation for our next meeting on digital identity pursuant to the drafting guidance that was presented today? I see a motion by Representative Lindholm. Can I get a second?
Second.
And I have a second by Ms. Long. All right, any discussion on the motion? Any discussion? Seeing none, all those in favor, please indicate so by putting your hand up in front of your face by the screen. All those opposed, please put your hand up by the screen. Joel, you're a voting member of that.
Then I would like to vote in favor.
All right, very good.
I thought as a liaison, I wasn't voting. I apologize.
No worries. One thing I will note, even though on the formal adoption of the legislation itself, and on motions along those lines that require it to be strictly legislative, then we'll do a roll call that will only include the legislators. But in keeping with our past practices, we want all of the members of the task force / select committee, the folks that have been involved, to be a part of these decisions. We always try and get towards consensus and unanimity. And so I want to make sure that everyone's comfortable with this support. So yes, on any motion short of a roll call, we'll get everybody involved. Thank you, Joel. It looks like it was unanimous, which is always great. Representative
Mr. Chairman, sorry.
Oh, go ahead, Mr. Chairman.
I did notice that Senator Nethercott was very eager to vote. She was in still frame mode. She came in a little late. I saw a hand pop up. Just wanted to make sure we recognize Senator Nethercott's vote.
I saw that enthusiastic aye vote. Absolutely. All right, Representative Lindholm, go ahead.
Thank you, Mr. Chairman. I'm assuming now is the time for any other kinds of motions in regards to the last three topics.
Absolutely, Mr. Chairman, or excuse me, Mr. Representative Lindholm, you were the co-chairman, so go ahead.
Thank you, Mr. Chairman. My motion would be in regards to the KYC AML aspect, requesting that LSO work with the Division of Banking on addressing a bill that would specifically put KYC and AML aspects into the fintech sandbox legislation, obviously keeping the sideboards in place in regards to upon approval of the commissioner and all those things. But I think it's worthy having a formal recognition of being able to work on that.
Excellent. All right. So we've got a motion, and ideally this is a very short bill, and I think it will be, because we just need to tweak our sandbox statutes to ensure that you could get that done. I have a second by Senator Nethercott. Is there any discussion on that motion?
Question.
Seeing no discussion, question's been called. All those in favor of the motion by Representative Lindholm, please put your hand up by the screen. All right. Those opposed, please put your hand up. That motion is carried unanimously. Excellent. Thank you, Representative Lindholm. Anything else that we need to accomplish before we go to lunch? Any other motions? Any other thoughts? Any other announcements? I see none. So with that, I'd like to thank Daza. I'd like to thank Claire. I'd like to thank Scott for all of your hard work. Christopher Allen for your hard work on not just this topic, but all of our topics. And Mr. Marr, thank you for joining us in this discussion as well today. I think it was very positive, and I really like the direction we're going with digital identity. I'm excited to see what the next meeting brings. So with that, thanks everyone. Great work. And we will be breaking for lunch until 1 p.m. 1 p.m. Meet back here. Mute your video and your sound, and I'll actually do both this time as well. See you all at 1.